about where's the Prime Minister and did he go yet. The difference, my friend, when the Prime Minister go, the Prime Minister now go for photo up. He might go for offer the people them solution to them problems. So guess what? In order to get the solution, you have to assess, you have to plan, then you can go to the people. It's not about photo app, my friend. That's what we are trying to tell you, you know. It's not about just photo app. The visit cannot be for you. It must be for them.
From the 99 people, the court
let me add to that fast. They are the same one who will criticize the Prime Minister if he does not show up with a solution for the people. Anyone would say he just went down there for photo ops. He's a wicked and uncaring Prime Minister. I would say, Mr. Holness, do what you have to do. The Member of Parliament is already working, providing shelter, getting giving them the necessary attention they need. But the government must approach the people of Cooper's Pen if they're going to do so with a solution.
Yeah, so they're not go down there with the me not believe that me never ever believe that Tova did to get herself immersed in all of this, because
no man, Tova is the representative of the people.
But all the tent they wouldn't go put on the people in land. Me totally disagree with that.
No, I think the people and give them permission to put the tents there, because the tents are permanent.
Yeah, remember, more houses were slated to be destroyed. It's because of Tova Hamilton intervention why they still remain there. A lady in an interview said that listen, her house was going to be bucked down today. And the only reason why it's still standing and she was able to save things inside there is because Tova Hamilton buyed her 2 weeks.
Right. So they are coming up with a solution, and that's when the Prime Minister will go. The Prime Minister now go for photo app, but it doesn't make sense to go down there just for the photo app.
So you're the latest one going, somehow, they manage now to put the Prime Minister and your wife name in this now.
Petal, do not report them buffoon we're sitting there when you hear them.
Yeah.
The Minister of Housing at the time sought to get a stay and to get an injunction against New Falmouth was that the minister, after New Falmouth won in the court, the minister claimed that he declared the land to be improvement area on Housing Act, and so he was at liberty to take over the land compulsorily. And a number of affidavits were put in. New Falmouth resisted the application, told the court of the history of the matter. And in fact, when the Minister of Housing's application went before the court, one judge heard the application, hearing only the minister's side, which is called the ex parte application, and granted the Minister of Housing an interim stay for 30 days rather, and set the application to be heard with both parties present at a later date. When the matter went at a later date with the two parties as the Minister of Housing and New Falmouth before another judge, the judge heard the application and the judge granted an order restraining in 2012 New Falmouth from interfering with the 99 people against whom the application was initially brought by New Falmouth. Then now, later on, when the application, another application for stay of execution, and after hearing submissions from counsel for the parties, one of the judges adjourned the matter and requested either the minister or one of the people who filed an affidavit to appear. According to this history of the matter that the Honorable Mr. Justice Frank Williams gave in the Court of Appeal case, he said on the 4th of May, Justice McIntosh delivered his decision dismissing the application which was brought by the Minister of Housing. The judge says neither the minister nor Shukir appeared in court. However, the learned judge recognized the presence of officers of the Housing Agency of Jamaica, Mrs. Simone Morris Rattray and Mrs. Janice Buchanan McLean, and handed them a copy of the orders which he'd made. There was no appeal from the learned judge's decision. The reasons for the learned judge's decision were contained in the...
So, the minister was requested at the time, the PNP minister, housing minister was requested to appear before the courts, and he didn't?
Did not.
Oh, okay, all right, go ahead.
Formal order filed on the 18th of May 2012.
Yes, the court opinion are public,
in the formal order. It is clear from the application to stay execution, so this is when now the Minister of Housing applied to halt New Falmouth taking possession, and the court denied the minister's application. These are the reasons the judge has put out in the order. Let me take a break and come back.
The Jamaica Civil Service Association.
Good of our nation.
So this is what the Court of Appeal recites as the reasons Justice McIntosh dismissed the Minister of Housing's application for a stay of a judgment previously given in favor of New Falmouth. And the court also dismissed the Minister of Housing's application for an injunction to stop New Falmouth from removing the residents from 2010. This is what the judge said. It is clear from the application to stay that it is intended to be an indefinite one, as there is no indication of a date or period for allowing the claimants to have the fruits of the judgment or award handed down in their favor. In other words, whatever it is the Minister of Housing said it was intending to do, there was no period by which it was indicated it's going to be done, and that indefinite nature, it allowed for some vacillation, some uncertainty about by when New Falmouth could have the benefit of the judgment that New Falmouth had. 2, the presence of legal officers from the housing agency may be intended to suggest to the court that the government is taking actual and immediate steps to assist the parties in a mutually beneficial settlement. 3, actually this is stated as 5, so it's 3, 4, 5. I suppose 1 and 2 were not that material, so the Court of Appeal judge didn't cite them. Given the history of this case, the length of the trial, and the efforts made by the court to assist the defendants there are the people who possess the land. Let me read it again. This is what the judge said. Given the history of the case, the length of the trial, and the efforts made by the court to assist the defendants who seem to have been misled by politicians into squatting on private property, notwithstanding their unlawful act. Gullible defendants. 6, the application. This is an application by the Minister of Housing to stay the order.
Play that again.
I will back it up again. So we can catch it.
Look, I will be PNP them at least.
Let me go back again. Sorry, the record, the way the recording said is kind of difficult to learn about. Let me try it again.
The court to stay its hand from the application to stay that it is intended to be an indefinite one, as there is no indication of a date or period for allowing the claimants to have the fruits of the judgment or award handed down in their favor. In other words, whatever it is the Minister of Housing said it was intending to do, there was no period by which it was indicated it's going to be done, and that indefinite nature, it allowed for some vacillation, some uncertainty about by when New Falmouth could have the benefit of the judgment that New Falmouth had. 2, the presence of legal officers from the housing agency may be intended to suggest to the court that the government is taking actual and immediate steps to assist the parties in a mutually beneficial settlement. 3, actually this is stated as 5, so it's 3, 4, 5. I suppose 1 and 2 were not that material, so they... or to assist the defendants. The defendants there are the people who possess the land. Let me read it again. This is what the judge said. Given the history of the case, the length of the trial, and the efforts made by the court to assist the defendants who seem to have been misled by politicians into squatting on private property, notwithstanding their unlawful act, this court empathizes with the gullible defendants. 6, the application, this is the application by the Minister of Housing to stay the order of the court, which was granted in favor of New Falmouth, and the application for injunction. The court said the application is iniquitous. That means it is grossly unfair, it is morally wrong, it is wicked, it is unjust. This is what the court said. This is not the first judge, this is not the second judge, and this is not the third judge reciting the facts. It's judge on top of judge on top of judge. The judge continues. It may be that the law is not a shackle to the lawmakers. That does not apply to the court, which must dispense justice according to the law.
I remember that
7,
famous words.
it is the court's view that the application is devoid of sincerity. It is an attempt to pervert the course of justice. And
So the court said, winner, that the PMP's application is devoid of sincerity. So them later, what the court are saying, you know, so you can't help the people, you know, but you keep leading them down this road.
Just the political,
Just the
political points.
The PNP was hoping to rig up a gerrymandering community, Chuck, to strengthen their ability to keep winning North Trelawney. They lied to the people, told them that they were going to help them, that they were going to give them, they're going to steal the man's land and give it to them.
And that is the attempt, you know, when they went, you see, all right, but let me look at that a different way. Say it was me and you who owned a piece of land there.
Yes.
And we couldn't afford the court. We couldn't afford it, you know. And the government now went and get an indefinite stay on we land. Whereas the court said there is no final, there's no time limit to this. So when me and you don't have no money if you go back to court, you know. So we that essentially lose the land just by that.
Because an indefinite stay means that you can't trouble them as long as you live now you're picking it. It does go into perpetuity.
Right? So if it wasn't a company that had the backing, they would have get the people.
Chuck, you know, that is a wicked act. That is a way how to circumvent the constitutional right of the man, you know. By putting an indefinite stay to say your property that you lawfully possessed, you can't have it because you're going to use a law to circumvent the system and just put this thing into perpetuity that you're picking, your grand picking, your great grand picking, as long as your bloodline live, you will never have access to that property. That's what the PNP try to do.
Abuse of the process of the court. This is what the court is saying to the Minister of Housing based on its application to stall a judgment that was given to New Falmouth years before.
Eminent
Application
domain.
is refused with costs. So they're supposed to pay the cost for New Falmouth. And as I told you, when you read the affidavit of Mr. Chisholm, Mr. Chisholm is telling them from 2002, he went to every agency begging them, please help. Please find somewhere to put these people. I need my land. I need this. I need that. Not one soul batted an eyelid. The court accepted that as fact. Because anybody can say anything in affidavit, but for the court to accept it, it went through a process of examination, cross-examination, passed the test of admissibility, passed the test of hearsay, and the court accepted it. Right? So, the court granted the Minister of Housing leave to appeal. Then on the 1st of May, 2012, the minister lodged a caveat against a certificate of title for the land and gazetted notice of the subject land being declared to be an improvement.
So this should be the caveat now where thing that they talk about in a film.
No, go too far, Chuck. The Supreme Court handed down a judgment that what the PNP tried to do is wicked and unfair to the defender, the claimant at the time. The man them say, all right, then court, you made a judgment here. Here how me go circumvent the court system. That's what the people play. Oh God, man, wickedness can do.
Era pursuant to Section 6 of the Housing Act, published in the Jamaica Gazette. So I heard Mr. Cousins yesterday talking about the gazetting. And when you look on the face of the title, it is there, gazetted. But there's a backstory behind it, and this decision outlines for you what the backstory is. In fact, I don't even know. Something else must have happened because I don't know how this caveat remains on the title with this particular decision of the court. It must have lapsed or it should have been removed by some means unless there is an intervening court action that has caused it to stay. So if you look on the title and you see this caveat, which is actually lodged the 1st of May, you may think that the Minister of Housing is properly entitled to some sort of equitable interest in the property. But based on this decision, which they appealed and lost, there could be no such entitlement to the maintaining of a caveat on New Falmouth's property, unless there's something I'm missing. So the court then goes now to the, after they lodged the caveat, they filed another claim in the court, a separate action now in 2012, a fixed date claim, where they sought several declarations, and that's part of what I took you to, including one that they were entitled to compulsory take over the land. They filed a notice of application for injunction, fixed date claim form supported by affidavit of Miss Simone Morris Ratchery, and it goes on. New Falmouth's lawyers, in response to the application filed by the minister, they filed an application for court orders, seeking as a matter of urgency to strike out the minister's application on the ground that the application was an abuse of the process of the court, and it was really in substance the same relief that were sought under the
I'm going to post it after this live is finished.
Other claim. Right? So all of the things I read to you before sound familiar because what they did in 2012 was to file a new claim where they were seeking sort of the same remedy. And so On the 21st of May, Justice Harris, then acting after hearing submissions of counsel, ordered by consent that New Falmouth and its agents be restrained from dealing with the land and from interfering with the occupants without the consent of the minister until the 7th of June 2012. So the matter was adjourned to that date to be heard. And the matter then went before Justice Campbell on the 21st of May 2013, continued over several months, at the end of which Justice Campbell ruled that the application before the court, which was brought by the Minister of Housing, was an abuse of the process. And so it dismissed the Minister of Housing applications and made the orders which I read to you earlier on in my views. So this is probably now the third, maybe fourth decision in favor of New Falmouth before 5 different judges. A couple of them granted interim injunction, a couple of them after inter partes hearing granted injunction by consent. But every step of the way, New Falmouth was policing the matter, begging for help. No government agency helped. Then the minister came and sought to do executive action, then applied to the court. The court said, no, you cannot usurp the function of the court. You cannot do something that the court has already ordered is to be done, and you haven't appealed that decision. We're going to stop it. And they appealed to the Court of Appeal. When they appealed to the Court of Appeal, these are the grounds that they appealed. They wanted the court to say that the judge, this is Justice Campbell now, misdirected himself in fact and law when he found that the alleged purpose of the minister is not for general interest of the community, but merely for private individuals voluntarily associated together for their own benefit. They say the learned judge, Justice Campbell, in finding that there's no public purpose to the compulsory acquisition, failed to appreciate that definition of public purpose would take into account the benefits that would redound to the community as a whole, and in so doing, they're saying the learned judge misconstrued the provision and the intent of Section 25 of the Housing Act. They also sought from the court agreement to say that the learned judge misconstrued the meaning of Section 25 of the Act and exceeded its jurisdiction by exercising a discretion reserved for the minister. They say they wanted the Court of Appeal to hold that Justice Campbell failed to appreciate and or misdirected himself in law when he found that the principles of res judicata and abuse of process were relevant to the proceedings before him. In other words, the matter try already for the same thing, and you can't come back and repeat them here in the subsequent thing. They wanted the Court of Appeal to say that the judge, Justice Campbell, erred in fact and misdirected himself in law when he found that the relief sought in both claims was the acquisition of the subject land. They wanted the Court of Appeal to also say that the judge erred in law when he found that the identification of public law issues is insufficient answer to New Falmouth's argument that the issues have been ventilated before the court. And so they lay out about 10 different grounds of appeal that they were challenging Justice Campbell's decision on. And a panel of 3 judges, Justice Phillips, Justice of Appeal Brooks, so these are all appeal judges, and Frank Williams, heard the Minister of Housing's appeal. This was heard October 2025 and April 2015 and April 2016. And on all of the points that they argued, those points of appeal that I mentioned to you, some of them that I read to you, the Court of Appeal concluded, in light of their analysis, I am unable to see that the learned judge, this is Justice Campbell, fell into error in his overall analysis and treatment of the issues in this case. The later claim, which is the one that the minister filed by fixed date claim form, having been in substance the same as the earlier claim and appearing to have the effect of attempting to circumvent the orders of Justice McIntosh, they clearly amounted to an abuse of the process of the court. That fact, coupled with the minister's failure to demonstrate compliance with the requirements of Section 6 of the Act, helped to seal the fate of his applications. In these circumstances, it could not fairly be said that the learned judge was palpably wrong. I am therefore of the view that the appeal ought to be dismissed with cost to the respondent, that is New Falmouth, to be agreed or taxed. 3 judges, unanimous decision, 20 I'm up on a break. You're tuned to Radio Jamaica Effective Nows. We're back with you. So, all of that whole heap of things, and I'm sure there are probably more matters. I've been trying to reach Counsel Juliet Mayer-Rose without success because I see her as a common, one of the counsel appearing in multiple matters for New Falmouth. If anybody knows Counsel Mrs. Mayer-Rose and if you can get a message to her, please tell her I'm desperately trying to reach her because it seems to me that every single thing that was legally desirable, possible, procedurally correct in seeking to have the court declare who is the owner of the land, having had the declaration, having the court order possession of the land, and then resisting what I consider, forget my consideration, I accept the words of 2 judges of the Supreme Court, the iniquitous application by the Minister of Housing. And I tell you, this is part of the challenge that goes on for me, you know. You have these guys who talk about judicial independence. The court assessed based on evidence before it. People subject to cross-examination. Submissions in law went before the court. After years of pleadings being filed the court, after months of trial before the court, and a tribunal of fact assessed credibility, look at the cogency of the matter in law, and came to a decision. And a member of the executive turned around and declared the area over which the court made an order to be an area that it can compulsorily acquire, with the intention of thwarting the decision of the court, put a caveat on the title, gazette its action, then turn around and sue the man who got the decision and try to get an injunction against the man. The man challenges it. And when the man challenges it, another panel heard all of the arguments and stopped the minister and said, no, what you're coming with, we've already heard and decided it, and your application is ungodly, unworthy, it is wicked. And what is happening is that you, the politicians, have made the people believe that it is okay for them to stay here and to consistently and constantly deprive the registered title holder of his interest in the land. That is not right. That is not constitutional. That is not legal. No. And they challenge it to the Court of Appeal. 3 judges at the Court of Appeal unanimously said the judge, I cannot find any way to say that the judge is wrong. So you, minister, you lose. Not only have you lost, you need to pay New Falmouth's lawyers their cost of the appeal here and below.
No, it wasn't Portia, it was Guy at the time, Morris Guy. Portia was the Prime Minister during this time.
The government that they must take action akin to what the Minister of Housing did in 2012, which the court has already frowned upon and labeled it as iniquitous. So the question is, do you think that any litigant who has so prosecuted this matter over nearly what?
Yes, guys, don't be afraid to press the follow button if you don't follow Chuck yet, you know. Follow Winner, follow Petra.
Brought his action, resisted, adverse.
1 second.
Hey.
Now, I see Mark Bowling, I see Isaac Buchanan, and I also see Dennis Meadows asking Andrew to interfere in what is taking place there. How am I doing?
Yeah, but they are so illegal.
But a criminal act, that would be a criminal activity. That would be a criminal act. The court is separate from the executive, or learned persons who wrote the Constitution. That you have to have the separation of power where the executive can't undermine the powers of the judiciary. Right? You write the laws and give it to the judiciary interpret the laws in the first place. So, and now you're calling Andrew Goodness to do the same criminal activity like what the PFP tried to do.
Is that putting there people like Emily, if you know, with your legal expertise, if you broke down the Sui man? Jesus.
Yes, you're right, Rickster. And then this then one can have the CCJ.
If we are a CTJ, then we didn't know show.
Applications consented to interim injunction until things are settled. You think that those people would not seek to ensure that they do enforcement according to law? So when I hear the story, the first thing I'm saying, but police can't just go so. Was there a bailiff involved? There must be a bailiff involved. So yesterday, I'm making all of the inquiries the day before. Was there a bailiff involved? Before the bailiff, is there a writ of possession? Because as I said to you, even though these orders were formed in the court, New Falmouth has to go a step further. When they serve the order on the people, some people might move, some people might not move. And for those who have not moved, they have to go back to the court and make an application to ask the court to please issue a writ of possession because they still have not been able to benefit from the fruit of the order. So I got a copy of the order.
No, Rob, it was Morris Guy, I think it was at the time.
And apparently there was a hearing on the 19th of May 2026 based on an application which was filed on the 30th of March 2026. So on the 19th of May, after the judge heard the attorney for New Falmouth, the judge granted the orders which were sought in the notice of application. There are 1, 2, 3, 4, 5 pages of defendants. So it's between New Falmouth and 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 99 or more different people as defendants. And this went before another judge. And for the judge to have granted the order for the reissuing of a writ of possession, the attorney needed to have satisfied the judge that all other orders in relation to this matter, they'd been served. And when the judge is satisfied, then the judge can go to the reissue. I don't know when the first one was issued. That I'd like to know, because part of what I don't understand is what happened in sort of that interregnum between, say, the Court of Appeal decision and this application for the reissuing of the writ. But as I've explained, it is when the attorney has a writ of possession that the attorney goes to then writing to the bailiff to prepare for the bailiff a sealed copy of the order so the bailiff can feel the seal of the court on it. Engage the bailiff, settle whatever fees. The bailiff gets in touch with the police. The bailiff doesn't deal with service of papers. The bailiff comes in because papers were already served. The court was satisfied that the papers were served, hence the writ of possession has been granted, and the bailiff goes in. If it's a levy, it's a warrant for levy, then the bailiff needs permission. But if it is for possession, no permission is needed. The bailiff goes, the bailiff will take out whatever is in the house, take them off the owner's property, and the bailiff's role based on the order of the court is to remove whatever is there by whatever means necessary, because the people have already been notified, must have been notified that at some point in time, you've lost the right to be here. Not right. You've lost the chance to be here. So that's how I know that it works from start to finish. I've been trying to reach the High Command, spoke with a member of the High Command yesterday, spoke with the Minister of National Security to get some more information, because yesterday John to say he understands that police detained young men, took them out before the operation and then took them back. All of that information, I need to understand what happened. Is it that operation, the pre-dawn operation, is it one and the same as the demolition action?
John Paul Upman, the same one.
And if so, how come? Because the police who go with the bailiff are not police who would be arresting young people or old people. They sort of go there just to keep the peace. That's why you engage them. Sometimes you send people to go feel the lay of the land, and when you realize that it is potentially dangerous, even the bailiff will say to you, we are going to need to have police presence there to make sure everything is okay. But those police invariably are not police who are detaining young men. So something seems amiss to me based on how I know that these things are supposed to work, which is why I'm asking for the High Command to say, what is this pre-dawn operation that took place? Is it connected with the bailiff and the police going there? And if it is separate, how
Yeah,
can it be so coincidental? Yeah? So before I come to anything else, there are a lot of things that have to be satisfied in my head. And the other question we have to ask is, really, what does a registered proprietor of land who has done all of these things, what else does he do? What else? I mean, when I look and I see that a young lady, they say, was put out in the the bus stop. Dreadfully awful scenes. But also the mere fact that a new generation is coming is indication that New Falmouth was never gonna get the fruit of its judgment. So, just what happens?
For the good of our nation.
And then down there breed up, then down there breed up on the people in land before they come off. And Chuck,
Continue to see who we can get from the high command. Nobody has responded yet.
I go get Judge Davis now. So
they usually have video evidence of everything and a show the video. How come you not see not one video release of them the boy they were detained? They usually have video police them when things like this are going. Not one.
As Judge Davis explained to us, it was 2 different operations. I think it was, me believes it was the police, more than likely, or the bailiff and his team here that there was an operation plan and use the same situation just to do for them one.
That's what I
They don't want us to know that there's an easy
advantage of the intel that something was going to happen now.
That's something I go on, so they went in.
Who released the information or the intel that would have raised the eyebrow of the...
I just want to play for you the audio version of his statement. Of course, it's voiced by him, so he just read his statement and sent it to media for publication. So here he is commenting on the Cooper spend matter, what he believes the Prime Minister ought to do, what both himself and the PNP believe the Prime Minister ought to do, and the basis on which he believes the Prime Minister ought to act. Here's Dennis Millers.
The People's National Party.
He can't sue, because he was awarded with costs, so the government have to pay him court costs, so he was awarded judgment with costs, so he can't sue.
Calling on Prime Minister Andrew Holness, in his capacity as Minister with responsibility for housing, to publicly confirm that a long-standing caveat on the Cooper spent property will be enforced following the demolition.
This is the illegal caveat where the judge ruled upon, of
approximately 20 homes that left more than 40 residents without shelter. The demolition took place in the early hours of Tuesday, August 11, when heavy equipment and bailiff, accompanied by large police contingent, tore down the homes without prior notice to residents, many of whom had lived on the said lands for decades. Our research revealed that a caveat number 1759455 was lodged on the property on May 1, 2012 by the Minister of Housing under the People's National Party administration.
Let it be known, Chuck.
The most honorable
Let it be known that the Supreme Court and the Appeals Court and the... Which one are the court again, Chuck? You go through 4.
You go through 4, so you go through the RN. Appeal.
Parish.
Parish Supreme appeal, then Parish appeal and Supreme, then appeal or appeal and Supreme. I don't remember which version they go first.
And all of them deem that the registered owner have the right to the property, and that what the PNP was doing was illegal. The PNP circumvent the court, the judiciary that we have, and put an illegal caveat on the title, and now Dennis Garden is calling on the Prime Minister to enforce illegal activity.
That caveat was challenged by the owners.
He's telling the Prime Minister to enforce an illegal activity.
So that would have been recording the ministry's equitable interest in the land. The caveat remains on the certificate of title, meaning that the property cannot be lawfully be dealt with without the consent of the sitting Minister of Housing. a role now held by no greater mortal than the Honorable Prime Minister. The Prime Minister cannot claim distance from this tragedy when his own ministry holds a record interest in this very land. Families are sleeping under tents while he stays silent. We are calling on him to state clearly and publicly that this caveat will be upheld and to outline exactly what his government intends to do to provide shelter or resettle these Jamaicans.
That's Dennis
We are
Meadows'
demand
double.
Immediate emergency shelter, a clear resettlement timeline, full public.
You demand immediate shelter. The people that have temporary shelter, but you never have to demand that them have it before. I mean,
I am challenging every single labor right that is here and well thinking Jamaica. You see that Emily sitting on a post, everyone on have a duty to post it.
Find it and post
every
it and play
social
it.
media platform. Because what they're doing is trying to set up the Prime Minister into becoming a dictator to undermine the judiciary. The PNP put that illegal caveat.
Send it to me, please.
All right, don't worry. I'm going to cut it and send it all over.
Disclosure of the government's role and that the administration invoke the local improvements community amenities
You
act
can find it on
to
Emily's
protect
views
and regularize the rights
on YouTube
of the current occupants.
That's Dennis Meadows. He's the constituency chairman of the PNP's organization in Northern Trelawney. And his statement came to me moments before the show. And he's the basis of his intervention is to say, listen, that caveat number 1759455, which was lodged on the property in question, May 1, 2012, by the Minister of Housing under the PNP administration. Housing at that time would have been handled by Dr. Maurice Guy, former Central St. Mary MP. And that action, Dennis Meadows said,
step up the screen for me, please.
Recorded the housing ministry's equitable interest in the land. Dennis Meadows says the caveat remains on the certificate of title.
Let me fill in the blank. Let me fill in the blank here. That is why new persons continue to go on the land because the PNP told them that the caveat exists and that the government have an interest in a man property which was illegal. And that's why when they ask the people, if all of this happened, why did you continue to build? Because the PNP tricked them and tell them so they have a right to the property when they didn't.
I have a question for you. Good afternoon.
Go on, DP.
Good afternoon.
Is Dennis Meadows a lawyer?
No, I don't think he is. Dennis Meadows a lawyer? I don't think he is.
Okay, so my observation after asking that question. So we saw what a lawyer has
One second, the DP. Who said the caveat is illegal? The court did so hubly. The court ruled that it was. What the word of the court use again? Iniquitous. Which means it was corrupt, illegal.
Emily used the word wicked to describe it.
Is that personal lawyer?
The judge also said that the people
and she also said unconstitutional. Unconstitutional too.
The judge said those persons were misled
come from the word
by parliamentarians.
Corrupt.
She said
wicked.
The judge also said these people were misled by parliamentarians to believe that they had a vested interest or they hold some form of authority over the legal ownership of the land.
You see, that is how they play on the people's mind.
Wicked and evil.
Yes.
Chuck, here's my observation. You notice that Isaac Buchanan is not the one that put forward. Mark Golding was on the property yesterday, and he mentioned none of this. Now, what is going to happen? Exactly. What is going to happen now? They're going to say, Meadows is representing himself, just like on the metal choppers. Them say him not have a problem with chopping. Only thing them to do is invest and give the woman them some money. This man is not a lawyer. George said it this morning. Say, well, on Meadows, I make this sound like it's a legal opinion he's sharing, you know. But like I typed in the chat earlier, PMP, they're criminals, and now they're dictating that Andrew carry out a criminal act too.
Yes.
But Dennis, we have the tape. Dennis said, he must represent himself. He's representing the PNP.
Yes. The two liars. You know, say, yo, PNP is strategic, you know. I know them are doing, Mark Golding, who's a lawyer, who PNP them big up and say, oh, he's a big top lawyer. Distance himself from that. You would have expected a legal mind to comment on the topic. Isaac Buchanan, who is the opposition spokesperson and humanity and whatever, who should have been speaking on this particular issue, distance himself from that, even though he was there.
No, he tell them to broke off them bedfoot. He tell them to broke off them
mind. He man put a non-legal mind to come up front and make the demand from the Prime Minister. So when it backfire, they can say, yo, Dennis Meadows not have no legal expert opinion, you know, so he couldn't say anything.
Winner.
He says that has the effect.
Just to back you up on that, winner. And I think Dennis is so stupid that he don't realize that maybe he's being set up. And the reason I said that, because when there is a public outcry now, what they will do is withdraw Dennis from the candidacy and insert the person who they want right there. While Dennis take the fall, and it looked like Mark Golding acted more ethically now to say, boy, yes, since this man spoke on behalf of himself and he did not give a legal opinion, then watch Mark Golding acting in the interest of the nation. You know.
Same, sir.
Of ensuring that the property cannot lawfully be dealt with without the consent of whomever the Minister of Housing is. Therefore, he's putting it squarely at the Prime Minister's feet, because he says the Prime Minister, of course, is the Minister of Housing now. And he says, the Prime Minister, I'm quoting him, the Prime Minister cannot...
I am not hearing
not claim distance from this tragedy when his own ministry holds a recorded interest in this very land. And he says families are sleeping on the tents while the Prime Minister stays silent. The PNP is calling on him to state clearly and publicly that this caveat will be upheld, and to outline exactly what his government intends to do to shelter and resettle these Jamaicans. The words of Dennis Meadows, the PNP chairman, of the PNP's constituency organization in Northern Trelawney. Let's take the break and come right back. This is Cliff Hughes Online. Relevant to matters that are consuming public attention. Clearly, the Cooper Spend matter is one that fits the bill any way you want to hold the bill. And that statement that we just played from Dennis Meadows, necessary to play it, I think, because it sets out the basis on which the opposition, PNP, is expecting the Prime Minister to act. But just a few questions here. I noticed in the statement, Meadows doesn't say, or perhaps he expects us to take as given, that the perspective he has given is a legal opinion, one. Well, let me stay there first, because if it's a legal opinion, we all know that doesn't make it sound, because you can have 50 trillion legal opinions. Which of them will be upheld by a court is another matter entirely, but is it a legal opinion? One. And then two, if it is that I own land, that there's a caveat on, following Dennis Meadows' reasoning. If I own land as a private developer or a private citizen, and the government has a caveat on that land, and Dennis Meadows is saying, based on the strength of the caveat, the government can do certain things with the land. What would prevent me as a private owner from also doing certain things with the land? And if, as his statement is suggesting, those things that the government can do with the land through its caveat doesn't necessarily involve the input of the private developer, or can act outside the wishes of the private owner because of that caveat. Why can the private owner not act outside of what the caveat says and perhaps gives the government the power to do? Is what I'm saying. So the statement is necessary to publish, because it groans again on what basis is the opposition calling on the Minister of Housing to act. We've seen that clearly. So we've seen what they say informs their perspective about the course of action that should be taken. But then that course of action or that basis has to be interrogated. Is the plinth solid? And the very few questions I've asked so far strike at the heart of that. What is the effect of the government having a caveat on land that I own? And what gives a government the right to act based on the strength of that caveat, but at the same time ties my hands from doing what I want to do with my land? So these are the questions that must be answered, because the fact of a caveat and the opinion as articulated by Dennis Meadows do not by themselves mean that the private owner's interests are ancillary or subsidiary to the actions and the potential actions of any government. That's just my view. And, you know, they say opinions are like, you know, where everybody has one. Legal opinions are of a higher level, but, you know, lawyers differ. So there you go. And then, of course, it goes to an independent arbiter, independent finder of fact to settle the matter one way or the other. But that's just something to consider. On the point of the detention, you know, that troubled me from the start. But if you notice, since this issue...
Don't let it go further yet. Don't let it go further. Because it seems as if George is not aware, or he didn't read the Supreme Court. You realize that he's not aware of what Emily Shields read from the Supreme Court and the Appeals Court, that in this position, the caveat is illegal, because what he did was circumvent the ruling of the courts, all 7 judges. Rule on the matter.
Judge didn't know. Judge didn't know.
He didn't know. And that's why he could have made a statement there. Because the action of the caveat is illegal.
You know the sad thing, Morris guy.
Beg a second. The Supreme Court ruled that the caveat is illegal. Does not.
No. The man put an illegal caveat. Did you listen to the Emily Shields?
Hold on.
Give me a second, bro. Let me ask you a question. Did you
ask the question?
Did you listen to Emily Shields?
Wait now. I love you to ask the question.
Did you listen to Emily Shields?
Good afternoon. Good afternoon, Petal.
Good afternoon. But in order for us to reason, Mr. Hugh Blair, did you listen to Emily Shields?
I listen what Emily Shields said.
Did you listen to her in entirety?
You a question.
No, did you listen to her in entirety?
No, I didn't get the time to listen.
Okay, so we can't really have the reason. You have to listen. Hold on. You have to listen to it first, because we don't want the opinion. We're not raising any opinion.
I am not giving you an opinion.
We're not well under. I think make we ask this question of Comrade Blair. Comrade Blair, what knowledge you have about the situation down there and the land, the dispute that has been going on? Give us the knowledge where you are. I am sure.
Hold
on. Let me finish the question to you. I am sure that since this whole thing started, you have taken time out to get yourself abreast of certain things. So just tell us where you gather so far.
I have always relied on the judgment of the courts. As it relates to ownership of the land.
Yes.
So, as far as I'm concerned, ownership of the land has been settled by the court.
And who the court said owned the land?
The court said the land belongs to and Mr. Chisholm, who is the primary owner of New Falmouth Resort. That as far as that is settled based on the judgment of the court. But listening you guys making the statement a while ago, I want to ask the question that if the Supreme Court...
No, come with me. You have to answer the question when me ask.
No, but I answer the question.
Tell me what you gather about the situation so far. I'm sure you do some research since you hear about it, you know.
No, I have always do my research. I know about the case before this section of the case surface. I know about the case. I know the computers are up now. They're still not up. Okay, all right, thanks. I know about the case from 2012 coming down. I know about the case. I know about the case. I used to listen to the brothers argue the case at Mr. Wilmot Perkins' program. So I'm well aware. And I trust the judgment of the court, that the court has settled the matter based on the evidence presented to the court. But the question which is arise now is as it relates to the caveat, which was said that there was a caveat put on the title.
Yes.
Our ownership of the land. But the question now.
So did you know that the court ruled that caveat was illegal?
Right. That's what I am learning, that the court ruled that the caveat is illegal. Okay. The question which I want to ask now is, does the government has a right to appeal the judgment of the court as it relates to the caveat?
They have appealed it numerous times.
Yeah, they got appealed already. 7 judges hear the matter. Much more.
7 judges.
It's not about the amount of judges.
No, I'm telling you how many appeals it has gone through. Not 7 judges at once.
No. There's a lot of appeal as it relates to the settlement of the land. I am speaking specifically about the caveat.
Yeah, and I'm telling you, yes, they did. They appealed it and the judge ruled against them.
The appeal court say illegal. So it should be removed.
The appeal court say, okay, so the only appeal then would be to the Privy Council.
For what?
As it relates to the caveat.
Why would the government persist on an illegal activity to steal somebody's land? The caveat was put there illegally in the first place, undermining the Supreme Court's ruling.
I won't speak to illegality.
No,
because
but
at the same time,
the Supreme Court made a ruling. Hold on, my brethren. Hold on, Mr. Blue. The Supreme Court made a ruling. The PNP housing minister at the time used
the government,
imminent domain. The PNP government, yes, used an imminent domain. No, the PNP government used an imminent domain to circumvent the ruling. Sir, you're interrupting me. The PNP government at the time circumvent the court's judgment of the Supreme Court by using an imminent domain to put that illegal caveat on the title. The appeals in an appeal court, bam, that's out. One more you want to appeal again.
Alright.
And awarded
Now go find that specific part that Emily recorded and play.
Yeah, tomorrow. I am going to do my own independent research as it relates to the caveat.
Oh, you haven't done any?
Pardon me?
I would encourage that.
Yes, we'd encourage that.
No, I'm going to do it. I don't like to speak on issues which I am not fully informed.
Mr. Blair, the judge labeled the action of the housing minister at the time as wicked and evil. And a fact that they tricked the people them in believing that the people had a rightful ownership in the land.
I won't go down there.
Those were the judge's words.
I judge the word that, you know. Say judge the word not important.
We know. The judge's words.
You went to Tuesday. Oh, yeah, it's Tuesday. Oh, okay, Brooklyn.
HR mute him. Go ahead.
No, one other thing I found very interesting
I think we should speak.
is that the PNP,
We should speak directly to the question that he asked. We should speak directly to the question that he asked. He asked if the government can't appeal the ruling that was made by the court about the caveat. Now, you Blair, if you know, let me not say that. You cannot just appeal a case like that, you Blair, to the Privy Council. Our Court of Appeal did not give the government the right to appeal. So therefore, that ruling cannot be appealed, you Blair. There's no appealing that. So it's not a case where because
they can't appeal to HR is that they know it was foolishness.
Right, because it's not a case where because the Court of Appeal rule against you, you're going to take it to the Privy Council. It is not automatic. It is not automatic. You have to get permission.
As me say HR, they know it was foolishness.
Yes,
then
sir.
No judge wouldn't hold it up. What they were hoping is that the other party wouldn't fight it.
Yes.
But luckily, as somebody with money, think of it as a poor Jamaican who don't have the money if you go so long in a law. What would have happened?
2 years, Chuck.
Government badness them that use and wickedness, as Emily say.
You know, see, I said, okay, and tell you how it thing to be done, man. Broke off a bed, put that boy, man. Chop the government, man.
The man house and not a container house either.
Yeah, you know, on a container house.
You know, I did ask Blair Royal though. Sorry, I did that cut you off.
In there, man, but in background noise, so we kind of mute him.
I want to know if we should trust what Emily as a say. Me would want to know that. What's your view on that, Mr. Blair?
Come here, Blair, you can unmute the answer, but your background noisy here.
Yeah, man. Yeah, remember, I'm just getting.
Yeah, man, me know you're there, man, so we understand.
Yeah. Family, what kind of question you say you ask now?
Should we believe what the eminent lawyer Emily Shields, whatever she stated on this topic, basically reading? Should we trust her or we should rubbish it? What's your take?
Did she read the document or she gave an opinion?
She read the document.
Okay.
Can you play it for him, sir? Make a play for him. Play it for him. Find a specific.
Mr. Blair, she read it and she quoted sections from it.
We're not supposed to stop playing.
Yeah, but I am going to
do the discussion and you do the research on it.
No, I never come to have a discussion. I came to ask a question.
Okay.
Because I have been listening to the discussion as it relates to the caveat.
Okay.
You understand? But I never know that the court has ruled where the caveat is concerned.
Okay.
Right? So it is for me now to go and research that part and to see the judgment as it relates to the caveat.
Okay.
The caveat was perverted. They said the caveat. I'm going to leave. The caveat.
Hold on.
Yeah.
I still want your Blair opinion. Should we trust Emily, even for her opinion to share? Should we believe Emily Shields? That may Mr. Blair.
No, there is always ambiguity in people's opinion, you know. But me and you can read the same thing and have two separate opinions. So we can't base things on opinion. We have to base things on ruling.
Emily's a liar. Emily's a liar.
Yeah, that does not mean anything. Liar.
Emily's a liar. So hold on. So have you heard what Dennis Meadow? Have you heard what Dennis Meadow statement say on behalf of the PNP?
All right, do me a favor, Blair.
You heard it?
I'm gonna play back Emily. I'm more you listen to it. Yeah.
So
mute and listen to Emily.
To take over the land compulsorily, and a number of affidavits were put in. New Falmouth resisted the application, told the court of the history of the matter. And in fact, when the Minister of Housing's application went before the court, One judge heard the application, hearing only the minister's side, which is called the ex parte application, and granted the Minister of Housing an interim stay for 30 days rather, and set the application to be heard with both parties present at a later date. When the matter went at a later date with the two parties as the Minister of Housing and New Falmouth before another judge, the judge heard the application and the judge granted an order restraining in 2012 New Falmouth from interfering with the 99 people against whom the application was initially brought by New Falmouth. Then now, later on, when the application, another application for stay of execution, and after hearing submissions from counsel for the parties, one of the judges adjourned the matter and requested either the minister or one of the people who filed an affidavit to appear. According to this history of the matter that the Honorable Mr. Justice Frank Williams gave in the Court of Appeal case, he said on the 4th of May, Justice McIntosh delivered his decision dismissing the application which was brought by the Minister of Housing. The judge says neither the minister nor Shukir appeared in court. However, the learned judge recognized the presence of officers of the Housing Agency of Jamaica, Mrs. Simone Morris Rattray and Mrs. Janice Buchanan McLean, and handed them a copy of the orders which he'd made. There was no appeal from the learned judge's decision. The reasons for the learned judge's decision were contained in the formal order filed on the 18th of May 2012. And this is what the judge wrote in the formal order. It is clear from the application to stay execution, so this is when now the Minister of Housing applied to halt New Falmouth taking possession, and the court denied the minister's application. These are the reasons the judge has put out in the order. Let me take a break and come back.
The Jamaica Civil Service Association.
Good of our nation.
So this is what the Court of Appeal recites as the reasons Justice McIntosh dismissed the Minister of Housing's application for a stay of a judgment previously given in favor of New Falmouth. And the court also dismissed the Minister of Housing's application for an injunction to stop New Falmouth from removing the residents from 2010. This is what the judge said. It is clear from the application to stay that it is intended to be an indefinite one, as there is no indication of a date or period for allowing the claimants to have the fruits of the judgment or award handed down in their favor. In other words, whatever it is the Minister of Housing said it was intending to do, there was no period by which it was indicated it's going to be done, and that indefinite nature, it allowed for some vacillation, some uncertainty about by when New Falmouth could have the benefit of the judgment that New Falmouth had. 2, the presence of legal officers from the housing agency may be intended to suggest to the court that the government is taking actual and immediate steps to assist the parties in a mutually beneficial settlement. 3, actually this is stated as 5, so it's 3, 4, 5. I suppose 1 and 2 were not that material, so the Court of Appeal judge didn't cite them. Given the history of this case, the length of the trial, and the efforts made by the court to assist the defendants there are the people who possess the land.
All right, Joshua.
Let me read it again. This is what the judge said. Given the history of the case, the length of the trial, and the efforts made by the court to assist the defendants who seem to have been misled by politicians into squatting on private property, notwithstanding their unlawful act, this court empathizes with the gullible defendants.
Comrade Blair, you understand what the judge is saying there?
I totally understand. I totally understand.
All right. Mute back. Mr. will come back to you. Joshua, where is that?
You know, I want to issue a concern in the form of a warning that I have, because I'm thinking ahead towards the future. And if this thing, notwithstanding the discomfort to the children especially, you know, and the babies, but if this thing is allowed to go in favor of the squatters, there's a greater danger that none of us have discussed that we can face or could face. Is that just like how it happened in the past, the distant past, some time ago, where it drove investors away, you know, because they would have purchased their lands or leased lands to do business on, to provide jobs for the Jamaican people, the very same poor people that we trumpet loudly that we are concerned about. That the investors may be fearful of doing jobs, doing business in Jamaica because of this very reason. So if anything at all, even though the law says otherwise, goes in favor of these squatters, then investors may be rethinking, they could rethink, you know, their decision
Joshua,
to invest in Jamaica.
Joshua,
Yes.
your fear is unfounded. Because
that is why I quoted what the law said. That is why I quoted the legality of it.
Oh, but Joshua, the courts have just made it clear that the courts rule that the registered owners of the land, and the court rule against the government. The courts will not allow the government to circumvent this ruling. So that fear is unfounded. Because what we are discussing here is that the system works.
It's not just this property alone, you know, Chuck, but we're heading down a slope that we head down before.
The system,
economy.
Yeah, but the system works.
No, and we have, in our bid to be political and grant political upmanship, right?
Yes, and the investors, Joshua, would have just gotten the message that the system in Jamaica works.
And yep. So no,
not even
it's
the
a warning
government
to
can
those who
circumvent the ruling.
Not even the government is not allowed.
No, and I understand, but it's a warning really to those who are pushing this particular agenda, talking about poor people.
But Joshua, the system works.
All right.
That's what we just. That's a big message here.
Chuck, let me try help Uncle Joshua. Let me try help Uncle Joshua. What Uncle Joshua is saying, even with Meadows' argument from the PMP.
All right, Lorraine, you're gonna get one box for you.
If we end up go the PMP way, then we're in trouble. That is what.
Then we're in trouble.
That is what Uncle Josh is trying to say.
Yeah, but the system works. Judges after judges after judges tell them, say, no, this is not what the law says.
Chuck, let me be DP's advocate. How many years this happened? If you did go in one country,
almost 20 years.
If you was an investor and you went to Antigua, you would have fight something like this in 20 years? You know, that find a way if you just get rid of it and move on and go invest somewhere else.
Yeah.
Yes, I move on.
Because all your money would have been tied up.
Exactly.
Right.
Although the system work, but how long we are going to go through? And when you do what is right and your order, people are call you wicked. Because that are sentiments now from people. The owner feel are wicked. Even if you might take you other way, should do it and little baby will end up get pushed out on the sidewalk and the bus stop. Now looking to say this, the people invest their money. Not 20 years. This is not no.
Right. And though 2 years ago, notice was given for them to move. I don't know, DP, if you saw this. DP, I don't know if you saw this tape this morning. Wherein one of the gentlemen on the property in the meeting with the PNP yesterday said that they received the notice, they contemplated, and I'm paraphrasing this part, contemplated moving, but they were told by the PNP, don't move.
Yeah, but that them do. Tell them to not move, because when we win, we are going to steal with it. Because again, how many of us on this platform right now knew that when Dr. Guy was the minister? Because I see Blair try deflecting on and say, I tell winner, don't say the government. Don't say the PMP government, say the government. So maybe you would say it another way. The PMP administration, that is better, Mr. Blair? So that them tell them, oh no move, because we are going to win the election. And when we win it now, we will just deal with it the way we have been dealing with it all these years. That was the plan.
But it's not based on JLP enclave.
So why PMP have so much interest in it?
No, it's not. It's not a JLP enclave.
It's not a JLP
enclave. Let's play in his narrative, guys. If it's a JLP enclave, why the PMP was fighting to keep the people on the land illegal for so many years? That makes sense? That makes sense, Mr. Blair?
We'll advocate for people.
All right, let me play some more of the recordings of Comrade Blake and hear it, please.
Chuck, before you continue, I wanted to speak on what was that PNP man that you played before? What was his name?
Meadows.
Mr. Meadows. Does Mr. Meadows understand that a caveat is a temporary thing?
No, he does not.
And it's not an indefinite temporary thing. It's for a particular period of time. Does Mr. Meadows not read? Not. Because even without being a lawyer, you know, if I'm going to make a speech on something like this, I'm going to read the information first.
Momo, Dennis is a pawn right now. He's been used by more than party.
I understand. But you see, for me, nobody now gonna use me because you're not gonna tell me what I can and cannot say because it's my reputation that's gonna be on the line.
Another way, I give you foolish if you go say you come say to
exactly.
Guys, you're looking at it wrong. It is not about Dennis, Mark, or Isaac. Okay? The statement was for the people who them know not reading and won't research. Is red meat for them base.
True, you're right. You're right.
They're not going to look up with one word. Our Dennis Meadows
understand that. But that statement is not only going to land.
As soon as Momo finishes, we come there.
That statement is not only going to land on the people that cannot read, it's going to land on the people that can.
They not care about that.
And instead of looking, me, mother have to care now because how I present myself is how people are going to take me.
Out of that from Meadows, and I'm sitting legislator say, broke off from Bedford, all when you're not affected, you're not from the era. Broke off from Bedford,
sitting legislator.
But this
sitting legislator with a criminal background you refer to?
Yes, him say.
Okay. The criminal background alone. You notice me not refer to not what I said say because the criminal background alone.
No, they say he has been what the term they use?
Reformed.
He has been exonerated.
No. When rehabilitated.
All right, so
I don't think you should be referring to criminal background as it relates to Isaac. I think that is...
No, the man is a two-time convict. The man is a two-time convict.
Hold on, everybody let me hear. Hold on, Blake. Let me hear. Hold on. Lorraine, go ahead.
All right. Chuck, my concern, and I have been observing and listening to everybody speaking since this whole... Are you hearing? You hear me?
Go ahead.
Yes, I'm observing, and I'm just listening. I'm listening to everybody speaking since the whole incident happened in Trelawney. And my observation and on a greater issue is that even though the court had given an order for these persons to leave the property which does not belong to them, I am asking two questions. One, what intention did these people, your grandfather, nobody's never dead left to give you. So it is obvious that the property belongs to someone. You must have had some knowledge that one of two things. When you're going to you're going to choose to go live on that property, is that one of two things. Either you have an intent to purchase, or you lose the investment that you had put on that land. Two, there is a municipal corporation that is in every parish. How has the municipal corporation played a blind eye to allow so many buildings to be erected on an illegal premises? And no action, no stop order, nothing have been put on these houses. That is my question. And I heard on a video call where somebody had said JPS came in and gave us electricity. How did that happen? How did that happen? Where does the buck stops with these authorities that are in Jamaica? I want a piece of property to buy. I have to adhere. If I do anything, if it's even putting up a wall to secure we're allowed to put up these buildings on these property without any intervention whatsoever from the local authorities.
Paula said stop orders were given.
Stop orders were given and they were not adhered to. What were the actions taken?
Can I respond? Can I respond a minute to that lady?
Sure you can.
All right. I will begin by saying 25% of the population of Jamaica, of 2.8 million people, which represent 700,000, live in squatter or informal settlement. 20% of the working population earn minimum wage. 500,000 persons live below the poverty rate. When we are having discussions like these, we have to factor those metrics.
In other words, make excuse to break the law.
Mr. Hugh Richards, Mr. Blair, let me break you for a second. No, Mr. Blair, you toss out some numbers there. And in order for the discussion to make sense, we have to make sure. Let me ask you this. You currently live in the United States. Does the United States have a minimum wage? First question.
Of course, it does.
How many people in the United States work a minimum wage?
I don't have the data on that.
Those persons working a minimum wage in the United States can they afford to buy a house?
Ireland.
Most people who work
a minimum wage in the United States, can they buy a house? No. Those people working, does United States have a squatting problem?
United States have Section 8.
No. Hold on, you Blair. Just don't jump ahead of me, man. Does the United States have a squatting problem?
I don't know of it.
You don't, that means there's no.
Yeah.
No, if you in the United States, if you in the United States go and occupy somebody's premises, what will the law do? What steps will the law take?
Good question.
The law will honor that it is personal.
And the law would come and remove you.
I know, and even in Jamaica, the law
even if it's minimum wage, you're working.
Even if it's minimum wage you're working.
Are they living below the poverty line?
It doesn't matter.
Oh, no, so no matter in America.
That's why your background. Yeah. So what may I try to say? The stats that you quote about people working minimum wage, people doing this. Blair, we have to stop use that as an excuse.
You hear me say, me sum it up for the man, he make excuse for breaking the law, bro.
Yes.
That's what he was doing.
The first thing where we understand and the difference between what you just tell me now. In a Jamaica, a person earning minimum wage can buy a house. Okay? That is one of the biggest difference where you just understand. In Jamaica, a person earning minimum wage can buy a house. The government will assist in buying a house. You talk about Section 8. We have NHT. The NHT give you a 0% loan. It gives you a grant of 3.5 million. Plus the government give you a social house. There are requirements.
Plus the indigent housing. Plus the indigent housing. Plus indigent housing.
So now that I have eliminated the numbers that you quote, that you quote, said, it is no excuse. I would love for you to now respond to Lorraine's question.
Before you do that, Chuck, Blair quoted some figures that are incorrect. The poverty rate, those who live below the poverty rate in the United States is 10.6% of the American population, which works out to 35.9 million. Those who live below the poverty rate in Jamaica is 8.2% of the population.
33 million.
Sir, I am telling you what I pulled down. Sir, I am telling you what I pulled down a while ago while we were talking.
It's about $1 million off. It make a difference in the argument.
Right. Which is 10 times larger than Jamaica's population. In fact, we can go up to 12 times larger than Jamaica's population is living below the poverty rate in America. And 8.2% of our population is living below the poverty rate.
You see,
and hold on, sir. We do not have a squatting issue wherein people, I shared this yesterday and I will share it again. There's a piece of property just in front of where I used to live here in North America. And I inquired about it and asked if it was possible to purchase it and build on it. And they told me that's not how it works. So I said, why is it empty? They said a house used to be on it and it burned down. So I said, if it burned down, them can't sell the land and people build on it. Them said, no, I know so it work. You can't just get that and notice that is a purchase. That is not even a capture. But the laws took precedence over the need. So we have to encourage people to do the right thing, man. If we want a forward-moving nation, we have to have a forward kind of thinking to match the forward-moving nation. We can't have the 1970s thing where people just walk in a people's house and take it over and run with the business people and run with the educated class. And that is what we're teetering on now. The Michael Manley kind of thinking that wrecked the economy of the 70s.
What I got from Blair is, as he answered Chuck, the law must trump in America, but the law shouldn't in Jamaica. And this is why I have a problem with PMP, because everything support criminality.
Answer Lorraine's question.
You want the answer to me? Let me stop that, make you answer.
Don't misquote me, I said
yes,
the law.
Could you answer Lorraine's question?
Hold on now. The law must take its course, both in the United States and in Jamaica.
So what are the excuse of the numbers them and statistics?
Hold on, man. The reason why I bring the statistic to you is to tell Lorraine that not everybody will be able to buy a piece of land.
That is true.
So someone got just teasing.
It's the same thing in the United States.
Guys, me want him answer the question. And every time you interrupt him, he question and answer.
Hold on. And in so doing, if 20% of the population is living in informal and squatter settlement, that means 700,000 persons are living in squatter settlement. What is the government doing about that? Whatever, if they remove everybody, what if they remove everybody?
What did
700,000. Where would they go?
Nathaniel.
Mute your mic, Nathaniel. Mute your mic.
Comrade Blair, I know you know start answer the question yet, you know.
I'm not gonna answer the question, Chuck.
What me hear so far is the same thing what DP said. You're trying to excuse the behavior.
Repeat the question.
Oh, you want Lorraine repeat the question to you?
Cause maybe him never hear. Maybe Mr. Blair never hear.
Hold on, look like he get him muted. Give him a second. But guy, he said he volunteered to answer the question, you know. That's why I want him answer it. And when you go out now, I go quote some big statistic number when I mean nothing. Because as little as Jamaica is, as poor as we is, our government make preparation so that a person earning minimum wage in Jamaica can go to the NHT, can purchase a home, can purchase a land. Thirdly, you cannot equate the people them down Cooper's Pen. We have built 3-story house, 2-story house as poor people. People hide behind.
I disagree with you. Said that not make sense because he's using it. Mega repeat to support wrongdoing and criminality. And that's why I'm quote the numbers. So I appeal to Lorraine's emotions now to say, come on, man, think about these people, minimum wage earners and people in poverty.
Which is why I mentioned that in Jamaica, a minimum wage earner can buy a house and can buy a piece of land to build. Minimum wage earner can do that in Jamaica.
Chucky, one other thing that the PNP has always circumvented when it comes to that minimum wage earning. In the United States, if you earn $1, it is taxed. In Jamaica, minimum wage is not taxed because of the threshold. So it falls beneath the threshold. In the United States, you have to do 2 jobs.
That's incorrect. Joshua, that's incorrect. That's incorrect.
Guru, Chuck, and DP, respond to that for me now, please.
Now, the sure minimum wage earners pay education tax, then pay NIS, and then we pay housing trust.
So hold on, let me ask you a question, and I'm going to ask you, is housing trust a tax?
Neither housing trust or NIS.
I am asking you a straightforward question. Is housing trust a tax? Yes or no? Is housing trust a tax?
NIS and housing trust is not a tax.
I ask you a straightforward question.
Then why you just mention them as tax, you Blair?
Is housing trust a tax, Blair?
I said no, Joshua. Education tax.
All right. Is NIS a tax?
So what happened to education tax?
Is NIS a tax? I am asking you a question. Is NIS a tax?
Joshua, I'm not dumb. But you don't have to repeat yourself and become repetitive.
No, but since we're having a conversation in front of 400.
You said minimum wage does not pay a tax. Minimum wage earners pay.
No, hold on. Joshua. Do not let Blair jar with down align our other discussion. The simple fact is, Blair, minimum wage in Jamaica can do things that minimum wage in America can't do. The fact is, Simply this.
I am not making an equivalent between America and Jamaica, you know.
Yeah, but
I keep my discussion
in order to
in Jamaica.
answer the question, you went down a line about talking how much people is earning minimum wage, which is simply you are trying to tell us that because they are earning minimum wage is why they are squatting. That was the line where you were attempting to go down.
Mr. Blair, you got answer Lorraine's question?
I gave you a figure. I gave you a figure.
AC tune up? Oh, okay.
Lorraine, can you repeat? Hold on, come over there. Lorraine, can you repeat the question to you?
Answer Lorraine's question when she repeats it.
Lorraine, can you repeat the question? Come over there, volunteer to answer the question. I want you to repeat it.
The question that I had asked more than one question.
Repeat both of them. Repeat both of them. I want come over there, volunteer to answer them. I want him to answer them.
Why is it that the municipal corporation allowed for persons to build on these lands that they have no permission to live on? Remember, when you're erecting a building, you must get permission from the municipal corporation. So that is
unless your name is Dennis Gardner.
He still had to conform, even after the fact. And also I am asking, why is it you and I, who are poor, as he has quoted before, but has chosen to adhere to rules, laws, regulation, and even if we have heard, but you have chosen a path to adhere and conform now, why is it there should be exemption for a selected few? What do you say to the persons who are working hard and are making sacrifices so that they can make they can save the money for the deposit for the land? Why you think those people or whoever are squatters should not do the same? What is so special about them that is different from any other Jamaican?
Comrade Blair.
The first question, does it relate to the municipality? I don't think I work for the municipality. Therefore, I am not in a position to answer for the municipality. That's the first question.
Comments on the IC.
Can you agree? You have said neither do I work for the municipality, but we know the role and function of the municipality. So can you say then that the municipality have heard and have let down Jamaica?
Well, I cannot use such strong language to you know, because there's a lot of metric and a lot of factor which sometimes the municipality itself encourages. Because we live in a polarized country and the hustle for vote is competitive, both at the municipality level and at the constituency level.
So are you saying of getting a vote?
Hold on.
It? Are you listening to what you're saying, sir?
Of course I am listening to what I am saying. I think very carefully before I say anything.
So.
The competitiveness of our political system encourages squatting too by both political parties.
By PNP alone, both political parties. PNP alone.
Joshua, you can say that, you know, because the action. Hold on, Joshua.
Are you aware, though? Are you aware that is why the Prime Minister is saying that he needs to address land tenureship because it cannot continue the way it has been?
The Prime Minister should address land tenureship, taking into consideration. Lorraine, if you are going to ask a question and answer it, no, ask the question, make a statement. If you ask a question, you will allow me to
I'm responding to what you are saying.
Not speaking to you. I think this discussion is bigger than your grade.
I will try to move like
leave this discussion.
Comrade Blair, we not go down that. We not. You see, we not go down the alley.
Comrade, you know, be like telling more intelligent and people and try to
we not go down the alley there with your Comrade Blair. Comrade Blair, what Lorraine is saying, and listen, we cannot sit here and you are going to say it's both government. Look, squatting. Can you know why, Comrade Blair? Because when this administration try to tackle the problem of squatting, you, Comrade Blair, and your party brand them as wicked as uncaring and these are Jamaican. Let me tell you something. And I don't know if it was on here with Chaps on Wednesday.
I have another statement to make.
Hold on. Give me a second. Let me say this. I don't know if it was here with Chaps. Chaps was here with us on Wednesday. And Chaps told us that there was a meeting planned in Central St. James with some people with the NHT who was trying to regularize them in lands that they would have lived on for years. Some of these lands were privately held, some was government. One of the private landholders would have given permission to the member of parliament, say, you can lose this, give him in writing, say, use this and legalize the people. That is being done. Last night, it was Thursday, the meeting, them say was jam-packed because everybody turned out in an effort because they want to hear what is the next move. Now, I am asked why you can't say this now, Comrade Blair. This thing down at Trelawney has been going on as so far past to 2 PMP administration. And rather than taking legal steps to try to assist the people, what they were trying to do was to illegally take the land from the people to give them. When them couldn't do that, they went around and promised the people rather than encouraging them to find somewhere else. They encourage the people to stay because when we come, we are going to go no. Remember, that is written in court document, Say politician promise, we say when them come in, we are going to get this. So you can't say both parties, Comrade Blair, when one party have a clear history of encouraging squatting. Isaac Buchanan, a legally trained representative elected to a parliament, just tell the people yesterday, I'm going to hear you are condemned what them say. So one party is the law, another party, and one party is a party that support criminality. And you know why they support criminality, Blair? Because of the same thing where you just said, them want the vote. They will say anything to get a vote.
Can I respond to you now?
Sure.
The actions which the opposition spokesman on housing has asked the Prime Minister to institute to benefit the resident of Cooper's Pen was done in Red Hills Road in Carl Samuda's constituency to benefit those in Red Hills Road who I suppose I will label them as a JLP enclave.
So,
can I be allowed to finish?
Let me stop you. I lived in
Am I lying?
Correct you because I lived in the constituency. I lived in the constituency. That's a lie.
Am I lying?
Of course, I lived in the constituency, sir. That's where I grew up.
Quite interesting, eh? Quite interesting.
Grew up in the constituency. Ask the girl that was used to the
no, I am not interested where you grew up.
Hold on, Comrade Blair. What is the action that was taken in Reading Zone?
That man is very rude when he cannot have his way. He's very ill-mannered.
No, I don't need to have my ways.
Comrade Blair, what was the action that was taken in Reading Zone?
the action which was taken to regularize the land issue in Red Hills Road is the same action which is being proposed by the People's National Party.
What was the action
in Cooper's Pen?
Tell us what was the action.
Well, it is a governmental action which can be taken by the Minister of Housing, who is the Prime Minister of Jamaica.
Who owned the land? Who owned the land and Red Hills Road?
Jamaica is not the minister.
The land in Red Hills Road was privately owned.
Who owned the land in Red Hills Road?
Which land?
Do your research, Joshua. You live in Red Hills. You're born in Red Hills. You're in Red Hills. No. Do your research. Do your research.
That is why I'm asking you which one, because we grew up with
250 people on my roadside. No research on it, you know. 250 people on my roadside. Yeah, simple. They are telling you straight. I'm pretty up like Joshua. 250 people on my roadside.
Can
make up a story, yeah?
No, all right. Play the statement of Luton Cousin yesterday in Cooper's Pen.
Comrade Blair, again I ask you.
Chuck.
No, Hugh Blair.
Play the statement of Luton Cousin
Hugh Blair
in Cooper's Pen yesterday.
Hugh Blair.
To substantiate what I just said.
What was the action taken in Red Hills Road?
What is a cousin is telling the government to do something illegal?
Hold on, Nathaniel. Comrade Blair, what was the action taken in Red Hills Road?
Chuck, play Comrade Luton Cousin's speech to the resident of Cooper's Pen yesterday, and you will get your answer there. And at least it would have given the benefit, the 300 odd persons listening will benefit from what I've been saying. Nathaniel, can you just now allow me? Allow me and Chuck to allow me and Chuck to have a dialogue, please.
Hold on. Comrade Blair, as you just stated, we have 390 people here. I have not heard Mr. Cousin's statement. You have heard.
You find all the statement them to play. I have asked you to play Luton Cousin's speech.
I don't have Mr. Cousin's speech on my device.
No, you can go on nationwide. Go on nationwide and you'll find out.
No, Chuck. When I see this sort of behavior, he doesn't know it. He doesn't know what I'm talking about.
But he has not answered the question either.
He does not know what he's referring to.
Which I believe him don't know what he's referring to. Now again, there's a difference, Mr. Blair.
Just play that speech from Luton Cousin and answer all of your questions.
Mr. Blair, could you give us...
Cousin say I tell the government because they talk the illegal. I try to set up
Nathaniel, you are not representing Mr. Cousin. Mr. Blair is trying to give the 300 people that is hold on. Mr. Blair have some information that he would like to pass on. To the 300 people listening. You said Mr. Cousin proposed a solution. Could you please just give the people a little taste of the solution? What injustice is he saying? That's all me ask.
Solution which was found for the resident of Red Hills Road in Carl Samuda's constituency could be replicated in Cooper's Pen.
Well, all right. Let me address this thing one time. Can't be different, you know. You see, Hugh Blair, my Prime Minister, Andrew Michael Holness, has not yet spoken on the matter. And whenever my prime minister opens his mouth and opens his microphone and address the issue, it will be a solution-based address. He will give the solution of how we are going to do for the people of Cooper's Pen. Him now go down there, go do no photo up. Him now go down there, go give the people false promise. He will come to the people and he will give them the solution. Simply put. Now, I have always said
the Prime Minister, the Minister of Housing, the
Prime Minister will, my Prime Minister, the one that me vote for, will, when he's ready, when he has done his due diligence, when he has met with the relevant authorities and come up with a solution, will address the matter then. Okay? And it will not be no, him now go down and go photo at the people and him now go down there with the empty hand. Go walk with the people without even a bucket of water to give them. Right? And the solution will be made. Is the same Prime Minister that has been solving the squatting issue little by little. And every time we try to attack somewhere to get it in line.
The Prime Minister is the one with the resources, the country's resources.
Yes, and he's the one doing the job. Yes, he's the one with the country's resources.
The same Prime Minister or CMP complains that cut too much ribbon. You'll be doing it.
He is in the best position to solve the matter.
All right, let me ask you another question. Let me ask you another question then. Since you say he's in the best position. After the hurricane, the PMP supporters was adamant that the Prime Minister should have waited on Mark Golding and they should have visited the people them together, right? Why didn't this time Mark Golding, who can take up his phone anytime and call the Prime Minister and say, Prime Minister, what can we do for these people? Let us come together, come up with a solution, and they will go down, they go meet with the people. You never think Mark Golding should have done that, Comrade Blair?
Well, if I should answer in the affirmative, then I would ask you the same question as it relates to Melissa.
You can ask the same question. I have no problem with it.
Right. Because the Prime Minister never took up his phone and called Mark Golding to travel with him. So why?
Well, let me answer this.
No, should I call the
You're at work now.
Prime Minister to chat there? No, I'm at home. I reach home.
You're at home. All right. When you go to work, well, I know when you go to work, and your boss want to move, does he ask your permission to move, or do you ask permission from him? Which is it?
The boss issue instruction.
Yes.
Does the boss
ask you for permission?
Hold on. No. Him can't ask me permission to move me. There's a chain of command. And once the boss issue the command from up there, it filter right down.
So what I'm saying to you now, Andrew is the leader. Andrew is the leader of the country.
Andrew is the Prime Minister of the country.
Andrew is the leader of the country. Andrew is the head of this country, the leader of this country.
He is the Prime Minister of the country.
So who is the leader of the country? I'm not going to say Andrew is the leader of this country.
No, he is the leader of the political party.
Andrew is the
Prime Minister. No, he is the Prime Minister of the country.
Comrade Blair, Andrew is the leader of this country.
Why think you did intelligent?
My leader, man.
He's the leader. You know, like leadership positions.
Yes,
like
my leader,
CEO is a leader of a company. You understand that?
The Prime Minister title is not a leader. The Prime Minister title
move forward with the
is Prime
statement,
Minister.
man, and stop waste time. Because we not tell this man no.
There is a difference guys, there's a difference between when the Prime Minister wants to move and when Mark Golding wants to move. The Prime Minister don't need to ask Mark Golding anything. He can if he chooses to. And as you said, the Prime Minister is the one with the resources and the means to help. So when the Prime Minister is going, he's going to help. If Mark Golden can't help because he doesn't have the resources, where is he going? You just say it.
No, but Chuck, you just contradict your own self.
No, you just said.
You said, hold on, man. You said, why Mark Golden never pick up his phone and call the Prime Minister?
Yes, me not contradict myself. Me straighten myself. Yes.
No, you contradict your own self.
How is it a contradiction? Let me repeat my statement.
Because
Mark
the Prime Minister
Golden, you just tell me.
Who he want to move with?
Come here, Blair. You just tell 200 people here that Mark Golden don't have the resources to help the people. That's what you just tell them.
He does not have it. Because the country resources,
so where is he going? What is he going to do?
Resources.
So why not call the person with the resources? Why not call the person with the resources?
Mark Golden's job is not to say the beatitude, brother.
Why? Let me ask you this again. How did the people of Cooper's Pen benefit from Mark Golden's visit yesterday?
Well, the benefit of Mark Golden is a leader in the country. Mark Golden is majesty.
I am not asking. I did not ask about Mark Golden's position.
Mark Golden, the opposition is a leader, but the Prime Minister is not a leader. Mr. Blair, you now make no sense, bro. You just said the Prime Minister is not a leader, but you just said Mark Golden, who is the opposition, is a leader in the country. Oh, no, listen to yourself.
No, DP.
And they might try to exempt Mark Golden from the government.
The Prime Minister.
Come with Blair.
Hold on.
That is what they are doing. How did the people of Cooper's Pen?
You should know as a farmer reporter that you refer to the Prime. You refer to
Comrade Blair, stop arguing with DP. I want to know, how did the people of Cooper's Pen benefited by Mark Golden's visit yesterday? When do for them? What did he bring? Did he bring a plan? Did he bring resources? How did they benefit? Comrade Blair, unmute.
You see, what you are making now is a political statement.
No, I am making a point.
You are making a political statement.
I am making a point.
You are
Chuck, hold on. Chuck, statement can't be questioned. You know, say, Chuck, move out with the man. How statement become question or question become statement? I ask you a question repeatedly after the man say, make a statement.
Comrade Blair. Let me tell you something, Comrade Blair.
No. Because what you want to, what you are driving in, you know, is to say that only the Prime Minister should go down there. Because
I did not say that, sir.
He have the resources of the country. Then what else are you saying?
When did he say that?
What are you initiating then?
When did he say that, Blair?
No, HR no mute. HR don't mute him. Comrade Blair, let me repeat. I am going to make a statement. Hold on, I am going to make a statement and then I will ask a question. Hold on, Comrade Blair. Again, Comrade Blair, you just told us that only the Prime Minister have the resources to help these people. That was your statement.
The Prime Minister is in charge of the country's resources. Remember, the Prime Minister administers the country's resources, not his resources.
Finance is in charge of the country's resources.
Comrade Blair, you just
remember the leader of the opposition is part of governance.
Comrade Blair, what I'm saying to you, if you said yes, he's in charge of the country.
That the opposition can assist the people. That does not mean he can assist the people.
Well, Nathaniel, hold on. Comrade Blair, he's in charge of the country's resources. That is where you say, okay? I am simply asking the question now. By Mark Golden going down there alone, how does that benefit the people down there?
So hold on now. So because Mark Golding cannot offer financial resources, he should not have gone. Because him can't get, hold on, so hold on. What about moral support?
You can't answer for you, Mr.
What about moral? Isn't moral support important as well?
Mr. Blair,
no, family, no, cousin, don't answer for me. Cousin, don't answer for me. I can answer for myself.
But you're not answering a question.
Of course I answer the question.
No, you made a statement. You not answer the question.
No, I may not answer the question.
So the answer is Mark did nothing for the people going down there. Nothing whatsoever. In fact, there were people, me hear record when the people run him away. And I said not even one buckler.
No. Those are political plans.
Me no business.
Those are political plans, and people get them 5,000 and them KFC.
So what you're saying, to me now is that the laborers go down and give $5,000. How much is that going to give?
So what you say now, your colleague Pratt.
What you're saying to me is that hold on. What you're saying to me, Comrade Blair, is that the labor rights will go at least give 5,000.
I never know that the
Mark gave moral support. Mark gave moral support.
Labor rights went down there, encouraged by their member of parliament to go down there to disrupt the visitor Mark Golding.
Do you have evidence of that?
Right now.
Comrade Pratt, you better known as your colleague, Doug.
Comrade Blair, do you have evidence of that plan? Do you have evidence to support that plan?
Listen. People were mobilized to go down there because they knew the leader of the opposition was coming. And they were mobilized to do what they did. Because
Chuck, sorry for disrupt your program. But didn't Mr. Blair say the era is a JLP enclave?
Yes, he did.
I am certain. No, I am certain. Why would
we need to send people down there?
The residents who were impacted by the demolition were not the one who were disrupting the visit of the leader of the opposition.
Yeah, then where is the evidence to support that?
Get to know that.
No, it's all right. You're going to ask me for the evidence. As it is, I should have a videotape of the person.
No, the thing. The difference between me and you.
Those are the type of things which is regularly done by politics.
Blair, the difference between me and you, Comrade Blair, the difference between me and you is that I don't know who was shouting it. We know we hear people are shouting. Me don't know where they come from. Here is what I'm asking you now. If you should have found out it. You should have found out if any of them was impacted by either being locked up or by demolition. Mr. Blair, Mr. Blair, you is a big man, he's a big man. We're there to teach people. And you see that word there behind me? It says we are fueled by facts, not opinion. When I ask you a question, I don't wish for your opinion. We deal with facts over here. So if you have factual information,
determine the question you ask.
If you have factual
determine the question you ask.
If you have factual information to support your position, then present it so we can make a judgment. Apart from that, we know why. Listen, I asked you the simple question where you go around answering. The question, the statement to me make, and sorry, Gusta, may I come to you right after this. Your statement is that Mark Golding don't have the resources to help the people. My thing is that if Mark Golding was interested, pause now. HR, mute him now, I can't talk. My statement now is this: if Mark Golding was interested in helping the people, he could have picked up his phone. He could have called the Prime Minister and said, Prime Minister, I see what happened and we need to go do something for them people. What you have in mind? Since you have the purse. And when you figure out something, let me and you go down there together. and we go present it to the people. Then.
And Chucky could have used that to say, I pick up my phone and call the Prime Minister, and the Prime Minister not even answer and say, nah, give me nothing.
And say, nah,
he could have said that. I would have want wicked political tool that.
I would have want wicked tool. But he went to visit the people.
If he meant truly genuinely could do it out and pocket.
He chose, no, I don't want him to do it out and pocket. I want him use taxpayers' money. Come on, go in and pocket, and we know that. He could have reached out to the Prime Minister. That avenue is available to him if his interest was to truly help and not exploit. His interest was to go down there and get a photo up.
Neither me or you don't know whether or not the Prime Minister and the leader of the opposition has spoken on the matter.
Did the opposition leader make a speech while he was down there yesterday?
He was making demands.
Did he make a speech? Did he make a speech?
But he must have to say yes.
Did he reference speaking to the Prime Minister?
The Prime Minister and the leader of the opposition has spoken on a number of occasions, and not one of them come out and tell everybody that they have spoken.
Comrade Blair, the difference between me and you having that conversation, me are not done. Me are no baller. Me are no extreme beauty. Me are no Michelle Bradshaw.
No, I'm not going down that. I am not going down that road with you.
Blair, wait, listen to me.
I am not going down in the name.
Listen to me. Me are no baller. Me are no extreme beauty. Me are no Michelle Bradshaw. Me are no none of them dunce people there. Okay? If Mark Golden,
I will take a lead top up.
All right, sir, no problem. If Mark Golden had spoken with the Prime Minister, Mark Golden would have said yesterday, I have spoken with the Prime Minister, and this is what we have agreed needs to be done. That would have been said in his speech going around it. Mark Golden went down there yesterday for him and him alone. Gusta, sorry, may I hold you back long time.
Well, I just Mr. Blame the dog address ask him a question. But since him gone, Mr. Chuck, we just reserve the question and you move on a little bit. I mean, I see him tune in one.
All right, sir. All right.
Yeah, man. Yeah, man.
Joshua.
Yes, sir. You know, the only thing that I can use to describe Mr. Blair is eloquent dishonesty. You know, and I hear Mr. Blair is at pains to do two things that, you know, are not mutually inclusive of each other. One, on the one hand, he's saying that the Prime Minister controls the country's financial resources. And on the other hand, he's at pains to say that the Prime Minister is not the leader of the country. So if you don't have that level of authority, then it must be the person who is above you who is responsible for the resources. Now, the word term Prime Minister, in and of itself, the word prime means chief or head. Right? We know that the chief of anything is the head of the same thing. So that means that the Prime Minister is the leader or the head of the country. Right? So for him to try to navigate that, you know, and end up knotting his britches together in the process, you know, it is not even worthy. You know, it's not even worthy of him uttering because he's doing a disservice to himself. Right? Mr. Blair has far greater eloquence than that, than to even think of going there, because he understands that he's speaking with a group of persons who knows better than that. Now, having said that, you know, back to the land dispute matter. The PNP has become suddenly righteous on this matter. And in 2012, the same 2012 that is referenced, downtown Kingston, they bulldozed an entire tenement yard. I don't know how much of you remember that, right? Bulldoze an entire tenement yard. Were they wrong? No, because they were following the law, right? And the difference between the PNP and the JLP is that the PNP thinks of political expediency in all that they do. The JLP think about what is best for the nation, right? Because every step of the way we hear Mr. Blair speaks, he's talking about what is political and what isn't. And when you ask a legitimate question, such as what did Mr. Golding do when he went down there? What did he do for the people?
Nathaniel, Mr. bring about Nathaniel.
Right.
Continue, Joshua.
Yeah, what did he do for the people, right? I heard you mention nothing about politics there. You just simply asked, what did Mr. Golding do for the people? You didn't say, you didn't even mention the fact that he brought the political representative that he had in hoping to unseat the current representative to the location, which was inappropriate, right? You just simply ask what he did, and he's going to say, you're being political. Is it that he's trying to be so political that he can only see politics in a legitimate question? Right? And finally, Patrick Atkinson, the former AG under the PNP, told the people not to move. And it's a symptom of a broader problem that we have through the PNP in Jamaica. And what do I mean by that? Because the Jamaica Labour Party has always tried to streamline things. For those who want to do their own research, you can and you should. Don't just take my word. Every time there is any form of lawlessness in Jamaica, every single occasion, the PNP is always at the helm of it. Do not take my word for it, whether you're JLP, PNP, or someone who is not aligned to any party. Do not listen to Joshua. Go and do your research and check every single step. Forget about what your granny said. Forget about what your auntie said. And even your daddy said. Every single step of the way where there is lawlessness, whether it be the taking of lives, the flaunting of the rules that is intended to make Jamaica better, right? To streamline the communities, the police wanting to do their job, political violence, you know, even the transportation system, the institution of Road Traffic Act. It is the PNP that is at all times flaunting the rules. We see Dennis Gordon sitting on the building committee of the parish council, the approval committee that grants license to people or permits to people to build, and he broke the very rule that he was tasked to enforce. And it shows you how the PNP operate. And we heard earlier one person mention about ISAT being twice convicted, right? And Mr. Blair was at pains to say, hey, he doesn't want to go there and we shouldn't go there. But when a lady, who was it Ensol Chuck, the lady who was appointed to the leadership of Ensol, National...
Yes, she was.
Right. Which was a government agency to lead it for the same offense as ISAT, you know. And she never spent any prison time, but ISAT spent prison time, served prison time. And the PNP demonstrated and insisted that the lady be removed from her position 20 odd years after she had cleaned up. And she didn't spend any time in prison. But here is a man who's a twice convicted criminal who's sitting in our parliament. And just in case people want to say that he's reformed, the fact that you're encouraging people to chop the line with criminal act, right? It says that this man has not been reformed. And we must see how the PNP operate. Everything for them is about using poor people as a pawn to achieve their agenda. And I yield right there.
Voice of Jamaica.
My thing is this week, this morning I was talking to one of my brethren, my taxi brethren, and I was saying, if this is a place Jamaica is going where we are being told the land is for the people. Now imagine me there in my yard and me see a couple of people just some black behind my house. And then tell me it's land for the people. No, me not right to my land according to them because the land is for the people, because PNP to me always twist things to try suit them campaign. Right, so then twist it. So if they know say it wrong, they swallow them pride and then just move along with a little thing, because I mean it work for them, I don't know. But somebody moving from my land, drops a couple block and start build house. And me can't take him off because the land for the people.
Yeah, no, I'm saying,
no. I am saying, what if everybody decides, yeah, well, we're taking literal. And Mark Golding get out tomorrow man and see people drop black pan the land. Can he remove them because remember it's for the poor? Right? No, what I say is people literally capture a land. You were given time to move. It'll go through 20 years in a court, back and forth, in a court, back and forth, back and forth. I will feel uncomfortable on the land where every time police officer come, I can't know this, can't give me if move. Me no build on the land, I move and go about my business, but however, these people choose to still build there. The BMP now is telling me that, listen, if you left your land, go to America for 12 years or 13 years, when you return to Jamaica, you have no right to the land. So a cousin said yesterday, he said the man left up the land, gone about in business or whatsoever, and they did not use the land for 12 years. So the people have the right to capture it. Our MP cousins at Tarpan. So even the answer thing said, but then what about the right of the owners? I mean, are you saying to me I can't leave my land no time going away? Because once I leave, people can capture it. The PMP, you see, is trying to get some political point to try to say, all right, we have fight for the people them. So, but then because this all backfire upon them. And here's my last point now. 1993, the land sale in 1993 under the PMP government. Cool? All right. The same PMP, so-called, took the land to court to file for the people. Look upon the confusion. You sell under your government. Then you take it back to court to so-called file for the land for the people. Remember, it wouldn't make no sense. So you sell it under your government. In the first place, you shouldn't have sold the land. Because you should have known that the people want land to live on. So don't sell the land. But however, you play the game, sell the land, get the money. Then I care about the same people them got code. Forget about the same land. Forget about the people them where you already sell them take off. It don't make no sense.
And so there's a description for that something there, voice. When they call it DP, when you sell a man something and then thief you back to sell somebody, there's a description for it.
I don't remember the name. You just have a baby can tell me. But then now you got a court. You lose the court case, right?
Is the chopper mentality?
Yes. You lost the court case, right? When you lost the court case, so you're ordered to leave the land. Now cousin is saying to us what they couldn't do over the years when they were in power. And you always must know break the law, and make the people then stay upon the land. That our cousins I tell you yesterday. This is the PMP this is the Jamaica that PMP created. And my grandmother was right. Remember when my grandmother cried, my last point, my grandmother cried tears when she tried to campaign for Siaga. The amount of misinformation was spread about Siaga. My grandmother stopped campaigning, let it go. She finished. She dead and never see Siaga win back. Because she could not tell nobody about Siaga. Because Siaga called the black scanner bag, Siaga this, Siaga that, Siaga that. And none of it was facts. None of it was facts. When they asked Blair, and you said, Blair, Mark Golding could have called the Prime Minister. You're a Blair, so you say, you don't know if he did, but yes, Blair no say, JLP going to go pay people for run your mark.
Yes.
You saw them wicked?
That's all them wicked.
All right, we're done.
Thank you, Vice. Jason Morgan.
By the way, the term is simple fraud here when you buy and sell something. It's fraud.
Oh, no, it's trap.
Right. But it's trap. Also... It falls up. Chop
them try chop the PMP government, the inventors of scamming.
The proper legal term is fraud, man.
The inventors of scamming is the PMP where sell the man the land and then try to go back a court, go thief the land from him. The definition of government badness. Jason.
Yes, sir. Good day, everyone on the panel.
Hi, brother. Good day.
Good day, sir.
All right, so I don't know. I was in dialogue with someone that live in Cooper's Pen. I've said it before, and the person told me that he did get a notice because he's from Clarendon.
Oh wait, Jason, are you telling the story the other night about the man who lose him roof and get the grant?
Right.
Continue, my boss. Yes.
So. You hear when he called me yesterday and tell me, say, he said, they asked him, say, like how Mark Golding come, what did Mark Golding bring me? Mark Golding only bring words and demands of the PM. And if you remember, why did Meadows did not run? What Meadows didn't say, he didn't have any problem with
scamming, with chopping.
It is scamming, right? And then you hear when I tell the people them down there say, you must order more than what you lose. Broke off bed, broke off whatnot. Yeah, all if you don't have a fridge, you have to say you lose fridge.
But Jason, I want you to tell the people them about your friend way down there. The one who get the notice, get the hurricane grant and buy back the material put at the sea. Tell them that story again.
Alright, so I have a friend that lived there and he told me that he got a notice because he's actually from Clarendon. So he went there and he settled there. He's a friend of him. They work at one hotel because he was working at, I think it was Iberia Star he was working at the time. And the friend tell him say he can't settle a Cooper spend because he was living in Lilliput. Then he migrated to there. And I think at the same time, couple years after that, Excellence start building so he get work over there. And him. So during the hurricane storm, he was blow down and he apply for the grant and get the grant. He had a boathouse. And then he went to the because I think the grant that he gets to go to a hardware, he could not use the money, was go to the hardware and order material. So he carry some of the black them and leave back some of the hardware. And him there plan for build and he black. Bear in mind,
at the same spot he get the notice for
at the same place he get the notice. Bear in mind that he got a notice in 2024. Remember that the storm came in 2025. October. And he get the grant. I think it was sometime in February saying get the money. And he buy
so
this
man get a notice, you know. Losing property, get a money from the government and was going back same place to build. Same place him go back, you know.
But and me ask the other night, me ask if he wish to company live contact and he said no.
Because all of them are going to sit back and play victims. Say, boy, we never know, they never give us any notice, then just come and run us off.
He said no one nobody hurt him.
Then he can't. No man, tell him to come and tell you his story, man. Anytime he ready.
He said no one nobody hurt him, so that's why now come on the live and talk because he know say some of the man them round they know not too good, and they have
Okay, those would have been the ones that the police would have detained in a separate operation. That's kind of.
No, I don't want to mention something earlier in the truck.
Yeah. Most of these man that got detained, they are not safe.
They are not safe. All right, sir. You're not going to say no more, Jason. Leave it right there, sir.
Yeah.
DP, where's the DP?
Me hear from both George and Emily this morning. Is that contrary to the lie that was spread that the people them wake up to their house and knock down 3 o'clock. No go so. No go so. In order to do a demolition and everything was according to the court, you have to have a bailiff. And Emily was questioning which bailiff did ever go out of them bed 3 o'clock. The next thing, you have some stuff by law. I don't know if they still a carry on. You know, say, back in the day, it was illegal for being a cemetery past 6 o'clock. And also, you couldn't buy stamp and I think thread and needle. They have some word for something where by law, you can't buy them something past 6. Yes. So you have to serve whatever or carry out within a specific time. The demolition started about 6:30. George mentioned this morning. I don't know if you did hear that in them thing.
Yeah,
so
man,
the people them so wicked and lie. Talk about at 3 o'clock, people them start. The next thing, a Punkus Mayor mentioned it, and there's a video with Nationwide. This lady was just going around and say, other person house, another person house. I saw furniture outside. So they got even time to take out things out of the place. To show you how wicked these people are. I may tell you.
All right, so Punkos.
Hold on, Joshua. Let make Empress.
No, it's just a bailiff. It's just a bailiff thing because I have personal knowledge regarding the bailiff matter. You cannot work before 6 o'clock in the morning. In some instances, even before 9 o'clock, right? And you cannot work later than 6. You're on a public holiday, and it should not be on Sundays. All right. So just to add some information there.
All right. Empress. All right, it look like Empress. It look like Empress fall asleep. What a person named King. The King. King. All right, King out. Empress fall asleep. So.
You know, I find interesting, Chuck.
I did not fall asleep.
Oh, all right, Empress is up. All right, come in, Empress. All right.
Should did I get lyrics?
No, not get no lyrics. Get distracted working. Let me tell you something.
Our overgrown grass.
The overgrown grass, no, it's well manicured now. It's been cut on the weekend, even though it grows so fast.
That made them supposed to say Empress, and that made them supposed to say.
Guess what? If they not listen, you don't listen to people. Listen, you don't listen to people who live in a basement, who live in an attic, and who live in an apartment.
No, man, squatters, them, man. They don't know about
owners, just speak to me.
Squatters, them are squatters. They don't know.
You get the message, squatters, and that's all they talk about is squatting. Now, I hear the story of ISAC going down. Now, guys, what is the role of the government? This is a private agreement. How is the government responsible for all of this shenanigan? And it doesn't matter. No one is actually going, because I find a lot of them haven't read the court document and all of that. Some basically are, as somebody who I know said, they're all jurists and they're interpreters of the law, and is basically putting the government at the center. This land was actually passed over by the administrator of Jamaica after their due diligence. I cannot say here, based on what I've read, that it was stolen from the children. If I even want to believe it, at the end of the day, I'd have to go with what the court says. Yes, I might in my mind think, hey, something might be shady there, but who am I? I have to just read what the conclusion is of these claims. And basically, it was then transferred to New Falmouth. Actually, I saw this corporation listed today, and I'm going to go deep dive to see who were the players. Not New Falmouth, but another corporation to which, let me see if I can have it named. I think it was saying to me that I'll tell you the name of it. It's called... It's also linked to Regional Resort Development Project. I really want to find out this because it said New Falmouth Resort Limited linked to Region Resort Development Project. So I'd want to find out who are the players in that section. How are they related to Falmouth Resort? But at the end of the day, what I'm looking at is these people were made aware. They've been made aware for the last couple of years. And even though they have been, people are still there coming onto the land. All right. What do you expect if this man wants his land? And I can't understand all of what everybody is going on up and about, the police and whatever. If I believe, this is my personal, everyone is saying it's abuse of power by the police. But guys, if those people were not taken, whether we're taken out at 3:30 in the morning, 6 o'clock in the morning, or 12 o'clock in the day, if what was done was not done, we would be talking about the amount of people that have been unalived at that location, given the action and what they were supposed to do. You have to be careful in carrying out such kind of broad evacuation.
Empress. Soji asked me to say something. So Soji asked me to mention that they walked with their own evacuation crew that went into people's homes and helped them to take out the furniture. He says he is aware of that.
I heard something of that nature. Also. Some people were saying that they were not. This young lady, and she was on here, met up with her, Scorpio. She said they were not made aware, but there was also somebody else was saying, yes, they were given notice. And we know they were given notice. And there's no way on this God's green earth that a bailiff, whether North America, we understand what bailiff and sheriff does. Who is there talking about a baby? Even if the mother was coming out of the hospital on the day that the scheduled evacuation is going to be, the sheriff is going to lock the door on her. Too bad, too sad. If she's in pain, they will also call 911 and take her to the hospital. If she is in a state of shock or trauma, they really don't care. They have legal possession to go and take possession of the property. They are going to carry out that order. So I don't understand how this private agreement ends up with Andrew Holness is the problem why this happened. The government is at fault.
Because
I want to understand. Help
me. Empress, everything that happens in this world, if they could find a way to blame Andrew for the war and the big leagues, they would have blamed him. Kimmy.
Ladies and gentlemen, boys and girls, I never graduate, so I just want somebody enlighten my darkness. What does Member of Parliament of East Portland, Isaac Buchanan, mean by if a dirt a dirt? Somebody can tell me what I mean, please?
He said that? When did he say that?
The day when he
No. He said it today.
No say.
Oh?
If a dirt, again? Who them no say. If a dirt a dirt, cause when me build my house as a poor man and put my baby mother in it and come tell my mother to come.
Oh, Uncle Chuck, it's 3 minutes. Is that okay?
No, play more.
There's more to just that part of it. Okay.
Play it, I want to hear it.
Who them no say. If a dirt a dirt, cause when me build my house as a poor man and put my baby mother in it
all of a sudden, I said a poor man
to come live with me. I'm
well, I knew that.
Pardon?
Mute it for a second. So Isaac Buchanan, who dey on TikTok every night in a swimming pool, a relax and a burning cigar and a drinking wine with the one whole heap of man around him. All of a sudden, Isaac is a poor man. Me say, I said, give me just 1 second, Kim. I make you finish it.
No man, there's a lot more. You're gonna get more upset. It's not done yet. It get worse.
All right, play it before me say anything. Play it. Finish it.
Yeah, it get worse.
Me not kill, me not rob, me not hurt nobody. Me just a try live. And no, me can't buy land. You forgot say me poor. You forget say I get where me come from. You forgot say me never go school. You forget say gold spoon in my mouth. Eh? You forgot say when I split up land and I never give it on because I now vote for no wicked people, whether you're PNP or GFP. So means a man will work hard and we find a place and 10 years we did it. 2 years short of adverse possession. Probably we did get the adverse possession, but when I go to court, we didn't friend them. Because after they detained the men in Trelawney, you know what they did? They went back and they escorted the bulldozer to carry out the order from the court. Yeah? The same orders when the court ordered that you must pay George Williams because you locked him up for 50 years. And somebody down in the office said, we not pay that nigga there nothing. I wait till him dead and can't enjoy it. You see the police I go up at Attorney General office and I say, who are the state attorney? Run the money. You see right now, Everton, Douglas and others, government get order for pay money, and what them do? They're busy, they're on vacation, they don't come for taxation, they don't want nobody get money. But when court issue order upon poor people, everybody ready for enforce it, card up in the roof for frightening.
Mighty God.
Yeah. You think right now if the United States is dep on the land they never pay nothing, you think any police could have go over there come talk about US Embassy lift up off of this? Eh? You think Donald Trump would allow it? You think any China will come out here where any piece of land them dep on and I think any police boy could have got there with court order and talk about they must come off it. Don't be no for frightened. So yeah, this is not a political election conversation. And no, this is not a racial conversation, but this is about oppression of one particular race. Classism at its best. Protection of property rights selectively. I was in court yesterday. You know what the woman in the dock is the landlord. And you know what police do? Come and lock her up because some girl in her house and don't want to pay the rent. And she know police and her police friend, she make the woman get locked up. And them have case down a certain street. So when you're black, your tenants them don't want to pay you. But when you're rich and you're white, the police will come and murder you.
This is confused, Ras. You know, this man are confused.
No,
so in one end you support squatting and the next end you support the landlord will get locked up.
Right.
You know, see this man confused.
Yeah, man. The man stupid pan overdrive, man. Stupid pan overdrive.
The man just a lick out say people must live pan land free. And then on the other hand, he must ball say when you're black, nobody don't want to pay. So what is his fight? What is in fight? I want to know that.
And then poor people can't afford place. So who rent the place then? Not much poor people. Eh? As
I pointed out to Hugh Blair earlier, in Jamaica, if we look a piece of the rock here, a person earning minimum wage can go up to the NHT, can buy a service lot from the NHT, they can go to NHT and purchase a home, they qualify for up to $12 million. $12.5 million from the NHT to buy a house. That is what a person earning minimum wage can do in Jamaica. When somebody like Isaac Buchanan come and I encourage people, say, use your poorness not as a drive to pull you up, but use it as a bed for lay down pan and you have to get up and go do nothing for yourself because you're poor, because your mother did poor and your father did poor and your grandmother did poor, so you don't have to do nothing. This is coming from a man, right, who sit down in poolside every night, who drive the biggest car, fly foreign when him ready, eat whatever and please. But he is telling you, so you not fit try rise to his level. That is a hold down mentality, and PMP no one, PMP leaders no one, nobody else. We have nothing. It's a dirty set of people. Them ISAT is a dirty boy.
Uncle Chuck, no, but I need to ask a question because I guess Kimmy I learned, but Kimmy not learn fully. You gotta tell me, say a man that tell the people them for scam the government and then come say if a dirt. Right? And call up the people them name and use the N-word. Call the woman girl. You gotta tell me say there's nothing at all can be done about this man? No, really and truly, nothing cannot be done. I'm answering a serious question.
I will forward that recording to the General Legal Counsel. And to the so-called civic group.
Guys, you can repost it too because I did the voiceover on my page, so you can repost it, make it reach out there. Repost it, guys. Share it, like it, and comment on it. Because Josh, there must be something can be done to this man. Something has to be done.
So here's what I'm suggesting, Chuck, with the influence of your platform. Since Marvin Liquor Smoke, according to Winner, did create a fake platform that don't have no merit. I'm going to suggest that you, Chuck, create a petition. And we petition some way, somehow, that they look at the laws in the parliament, the code of ethics in the parliament. Something like this should be included in the code.
I recall Mark Golden saying that all his members signed the code of ethics. Is Isaac being line with the code of ethics that everybody signed?
That is what I'm talking about.
Is it? There's something, nothing can't be done?
That is what I'm talking about. The code of ethics that exists. That if it doesn't exist, that then look at the code of ethics so that utterance like these will be reason enough either to sanction or to expel the person from the parliament.
And Chuck, when was the round a Irwin side, round they call it Tucker. Me have a bridge around that $7,000 and pay a month for rent, for mortgage around there now.
$7,000 for his mortgage. Where did he get his mortgage through? The NHT?
The NHT, right when the pass Irwin and grown.
No, man, at first possession, man. At the same getting mortgage.
Hold on, Joshua, hold on. So what you're saying to me, sir, is that there are persons in Jamaica, at least one person that you know of, is paying $7,000 a month for a mortgage.
$7,000
$7,000. Minimum wage is $17,000 per week. Minimum wage is $17,000 per week. And somebody can pay $7,000 a month for a mortgage. You see, guys, let me tell you, man. On a top make PMP hold on a dung. Is a set of hold on people. Them don't like the people prosper. They like when everybody a farm up and a beg them sitting.
And right now, they might build some more house around at the same part around this, but
that's close to where estuary scheme is built, right?
Yes.
All right. And remember, daily these people is coming up here to tell us that there is nowhere in Jamaica that minimum wage earner can buy a house. $7,000 is the gentleman's mortgage.
$7,000. What pay for mortgage from must about 2020 and get the house.
All right.
And because a lot of people is around there right now, they make more house around there.
Thank you very much, Jason.
It's about 15 minutes away from Montego Bay.
No, man, I know where Irwin is, sir. I think Madden's have a funeral plot. Was it Madden? There's a funeral plot heading in that direction, if I remember the era clearly, right? But nonetheless, you know, I want to encourage those who are listening to us, and this goes beyond the realm of politics. Stop listening to the PNP. Anything the PNP says, though it sounds like it's a political statement, make sure you research it carefully. I'm not about just ask somebody. Dig up the documents, go to the relevant agencies, ask for yourself. Do not listen to the PNP. The aim of the PNP is to let you feel that you're a perpetual victim and that there is no other way out, and then you have to resort to illegal activities, right? This is what the PNP does, and then they prey on you and your ignorance. There is a way out, my friend, my fellow Jamaicans. There's a way out. Do not listen to these liars that don't mean you any good.
Same so, Joshua. Same so. Churchill, you're quiet for your join.
Yeah, man, I'm here waiting my turn.
Go ahead, Churchill. I will yield to you, sir.
Yeah, man, big up on yourself, as usual. But, you know, listening to all this, you know, so Jamaica has a long way to go. And it just seems like the Prime Minister, sometimes the common sense is total nonsense. Sometimes. And it seems like the government gonna have to issue a handbook. But then again, some people not gonna read it and claim innocence. They're gonna claim victim by innocence, because in today's day, you hear people out there.
Let me respond to King Solomon. King Solomon said, I represent investors in the diaspora and international investors, and they're watching this closely. Well, you can tell them, King Solomon, that the court system in Jamaica works. Simply put.
Yes, the court works. So I'm saying Jamaica
Sorry again, Churchill. They have never been an investor-friendly party or administration. They have never. From 1970, there have been anti-investment and anti-development. Same so.
Anti-prosperity, remember that part?
Mm-hmm. Sorry, Churchill.
Them poor so that you can lie to them and make them feel like they're always a victim.
Come to Churchill.
Yeah, man. So I'm saying you listen to some people on different platforms claiming that everybody supposed to have land. No, just think of it. Everybody's supposed to have land. You know what that does? That means government should just give out people land and give out free things to everybody. Then who would want to work to buy a piece of land if you can't get it free? You know what developing a country is? It's about working. It's about doing your part to develop the country and develop yourself and your family. If the government has to come and always give out, then why should you go and work? To develop yourself and to institute something, of pride in your family to say, we've worked for this, we've earned it. Enough of these people over there, over in Cooper's Pen, they could build a mansion or whatever state they carry their house to. That same money could have bought a land and they would have more pride. They wouldn't have to go through all this problem.
Airbnb run it too. They never talk about Airbnb running up on the land.
Yeah. You know, here the guy said, was it Jason? Said the guy get money from the government for roof and him plan to buy a block to put the same place. Now, what is the mentality? What is the mindset of these people? After him get notice, him still go buy black, get free money, and go get black and put back the same place.
At the same place.
No,
the same place.
How do we get to these people to say, look, man, you have to uplift yourself, you have to find a work and help yourself and your family.
Churchill, I've said it every day and I'm going to say it again. Opportunities are in Jamaica. You can own a house, you can own a piece of property, you can build a house as big as you want. What we have to stop doing, and sorry, I was about to make this point earlier and I took me to make the point. I've always said there are a couple of people in this country that I do not like. One of them is the Rasta man over so. I don't like Damien Crawford. It's not because of his politics why I don't like him. I don't like Miss Kitty. I don't like Raga Shanti. Me not like them people there. Not because of them politics. Here's why I don't like them. These are people that may have, well, Miss Kitty never born in Allah, but between Raga and Crawford, both were born and grown in less than ideal circumstances. In other words, them born poor and grow up poor. But them work them way through. Work them way through and build riches. All of them now is rich and can claim say them better. Them know exactly which part them night they now come from. And for them children will never go through the same thing where them go through. And that is a plus, that is something to celebrate. And every day, them sit down and them tell you how them are poor people. And then try to tie themselves to poor people, me a poor youth. Isaac Buchanan is not a poor youth. Damien Crawford is not a poor youth. Miss Kitty has never been poor a day in her life. Not a single day in her life. But they keep trying to equate themselves with poor. Okay? So people look at them and say, oh, yeah, man, them a poor man, them a one of we. No, they are not one of you. They are somebody who can teach you the way out, but they will never teach you the way out because them rather you look up to them and beg them every time. You have never seen one of them go down to the ghetto and tell the ghetto youth them say, boy, I saw me make it out, you know, do the same thing and you will make it. No, we are poor people together. No. Damian Crawford built one house bigger than the Prime Minister own, and that is good. But why not encourage other people to do it? Eh? Why you not encourage the people? Why you not show it every day and say, see, I work and build this?
I must say, having farming too, you know.
You having farm business?
Yeah, big chicken farm.
Chuck, you are 100% correct. Years ago, one of the names that you mentioned, which I will keep off the air, we came together along with Dwight Peters of Pulse and another person who is internationally known. And we decided we were going to form an organization to take street children off the street. And we had 2 meetings and we outlined the plans going forward. And believe it or not, it's only one of those names that was mentioned turned up after that. Right? The one who is internationally known turned up, and the 2 local persons never come back to the meeting after giving us all the nice words that we wanted to hear. Right? We were going to take the boys off the street, you know, the boys who were, you know, challenged and suffering, and, you know, some of them don't know them parents and some of them wipe car glass. Right? And this was the plan, and we outlined everything, a business plan and everything going forward, and looking at donorship and sponsorship. And they've never come back. So a lot of these people who you see in public go on like them care about poor people. It's lip service. Lip service.
Same, sir. Who is Glenn on that? Glenn? Glenn, not in the mood, you know. Right? But listen, the opportunities there, right, is the only place where me know, better than the great United States, better than Canada, better than England, there is nothing in place for a minimum wage earner in the great United States to buy a house. It no exists over there. If you're a minimum wage earner, you have to live on government benefit until you die, unless you go find your way off. In a Jamaica, a minimum wage earner can turn up at the NHT, qualify for a home loan, get him home loan and start paying mortgage. Jason just tell me $7,000 per month. Minimum wage is $16,000 per week. So that is less than half of a weekly salary you're paying as your monthly mortgage. Now,
less than a third.
Let me tell you the stupidity of PMP. And this is how PMP reason. I was having this very discussion with a PMP. Let me talk about the dumbest one of them all, in name Alvaro, who said smart. Let me prove to you how dumb Alvaro is. We were having the same discussion. And when I tell Alvaro the night, say when you get your minimum wage, your salary, when you get your mortgage, you cannot pay a little over $14,000 a month for your mortgage. Alvaro said, then who you go pay that and pay rent same time?
What you say a while ago, Chuck?
Alvaro, the dunce battle them have over, so say I'm a genius. Ask who you go pay mortgage and rent same time.
Look, I submit to you that he didn't hear what you said.
Maybe I didn't hear what him say. Not pragmatic, I don't lie me, I tell you no.
Nobody can be that stupid, Chuck.
You'll be surprised. When you dumb down yourself for your audience, after a while, it becomes contagious.
Wow.
Thank you, common sense. Common sense, I'm hear it. I don't lie me, I tell Padden.
No,
man. Jordan, what me can do for you, Jordan? Jordan, me and you, we just now you just can't have a discussion. Yeah. Well, they're gonna second the people.
When you're that dumb, you need an Emmy award to be that dumb.
Mr. Kraskill, how can I be of assistance to you, sir?
What's up, Chuck?
Dad, you vibrate on a far different frequency. You vibrate AM and media FM.
Yeah, but as in, it's nothing wrong if we don't agree on it. I have to agree.
I agree with you, sir. We don't have to agree.
Well, I would disagree with you there.
True. Sorry, my apologies. Let me apologize to you. True. You know, teach nobody with sense nothing.
I disagree with you there as well.
All right. How can I be of assistance? You've been listening. How can I be of assistance to you?
Well, I just joined in actually, so I just wanted to listen to what you guys were saying. And
I was asking the question. I don't know if you can answer me. What benefit did the people down at Westmoreland get from Mark Golding's visit yesterday?
As in
because I'm thinking, let me tell you the genesis of my question first. I don't want you to think I'm just being facetious with it. I'm give the genesis. I believe that if Mark Golding truly wanted to help, he would have called the Prime Minister, work out a strategy to respond to the need of the people, and then he can go down there and say, well, I've called the Prime Minister and this is what we're going to do, and look forward to this in the very near future, and something like that.
That Westmoreland?
Yes, Westmoreland. Well, I told the people at Westmoreland want him to, in Chilani. So what benefit did you think they gained from his visit?
Well, yeah, but from his visit, from what I understand, it was just to go and check out what happened, and then essentially to recommend to them that they do need to get lawyers and that they need to push the case forward to go back against the overall process that they've done there.
Get lawyers to do what?
To pursue either gaining the land or gaining some sort of...
The court has ruled, the Supreme Court, the appellate court, the highest court in the land, Jordan, has ruled who the owner of the land is.
Yeah, and that's fine. So they have to possibly appeal that again. So maybe go to the Privy Council for that specific part. But for the actual things that took place to get them off of the land, to the detainment, all of those things. No, all of that now is fresh case. All of that is
to
human
get them
rights.
off the land. So are you telling me that the court of the land made a ruling? Are you telling me the ruling that the court of the land made that these people need to take possession of their property, and that ruling would have been executed on Monday? Are you telling me that the court was wrong?
Well, as in, based on the entire history that I've heard about this, a couple of things are missing for me. So the 21 kids, they were
like
not
what is missing
sought after. So the 21 children that are of Jobson, those kids should have been looked after. Those would have been in the responsibility of the administrator.
Hold on, sir. Those kids have nothing to do with the squatters. Them not have to do with the people.
No. Well, you see, I don't know that. We don't have proof that none of those people on the land now are any of his kids or grandkids. So they would actually have some intent.
Jason, Jordan, is anybody on the land claiming ownership to birth or anything, to whatever?
No. I don't know. But
then
the thing is that it doesn't matter.
Jason,
it's not just if they
Jason,
are.
that's why I'm saying, Jason.
Hold on.
Sorry, Jason. Jordan.
I get you.
Why, Jordan? You don't like Jordan. I don't like small-minded discussion, Jordan.
This is
you
not
and
small.
I know. Do you think that one of the children that live on that piece of squatting land belong to the man who own nearly 100 acre land?
He doesn't think.
Well, Chuck, that's what I'm saying. I wouldn't know.
Jordan, the answer is a simple no, Jordan. You don't have to live there.
Investigation there. Hold on,
Jordan.
Jordan. You just said the kids don't matter. What I'm trying to say to you is the entire situation from 1967 till now. The kids would have been minors at the time when Jobson owned the land. Even if there was, yes, the suggestion that it was sold, which we still don't have proof that a check was actually paid to Jobson. There's no proof of that in any of the court dealings. No, there's a statement 2 years after the sale that they say a payment was done, but that's still not an acceptance from the original owner who would have been Jobson. So you see, those parts there make me have to question the entire case overall, because I'm wondering, well,
what does that have to do with these people them that occupy the land?
No, so Chuck, it's not. That's why I'm saying to you, the people who occupy the land now, I would have a different conversation there. But where it concerns
but
the
those are
issue of the land itself,
Jordan,
I would want to also hear more there.
Jordan, that is the discussion, sir. The children of Mr. Jobson was not bulldozer of the land. No, it was a bunch of people that had no legal claim to the land.
Listen to what
HR, no HR. Jordan, the people that was bulldozed has nothing to do with the children. I'm asking you the simple question.
No, but Chuck, you don't get to determine what has to do with the children or not.
Jordan, is there anybody in the court document that is listed as the children as Mr. Dobson?
In the court document right now,
yes.
The children are not listed.
Okay.
Meaning, so we don't know if there are children on that land or children of his children on that land. We don't know that.
Jordan, have a good day, sir.
Yeah, Chuck, I would like to ask Jordan a question before we go. I would like to ask him a question.
No, I want.
I'm going to talk to Jordan. Jordan, let me start.
Yeah, but I don't know why you're getting upset about that, Chuck. I don't see what's wrong with looking into it more.
Jordan, Chuck says he's finished. Can we have a little reason together, you and I, please?
Yes.
You seem to be somewhat concerned about the children being left out of the picture. Now, if they were indeed the rightful owner's children, then they wouldn't have been ruled to be squatting. There would have been heirs to the property.
No, that's not what I'm saying, Joshua. That's not what I'm trying to get at. That's why I said I'm not trying to assume or say that the people on the land now are definitely Jobson's kids. What I'm saying is, when you look at the overall case from 1967 till now, there are a few things that stand out. There's one, that New Falmouth wasn't incorporated at the time of the purchase. Two, there's no proof in any of the court hearings or proceedings that says a check was actually received by Jobson, the owner at the time. There's no proof of that.
All right.
So there is, of course, we know that the court proceeded, and so we're not gonna deny that because that happened.
All right.
But
so let us use.
Hold on. The Administrator General was responsible for the property and for those dealings. They would have also been responsible for handling where it concerns the children of Jobson at that time. Because even though, yes, he doesn't have a will, what should have happened is that if there was no proof of that sale by Jobson, then that land would be entitled to those 21 children. That would be a fact, not a question. That would be a factual piece of evidence. However, because something happened there in the past, I don't know what happened, but something happened where they did not pursue to get proof of that check payment to Jobson, meaning
you studied law?
Actually pursue to get full proof that it occurred. No, I didn't study law, but I studied reading.
What you studied?
Hold on, Philippians. I'm waiting on him to yield because I want to.
Yeah. So basically, I'm finished there with that point. But what I'm saying is, it's not guaranteed that people who are on the land now.
Hold on,
Joshua. Let me just finish that last one.
Hold on. You put a lot of things on the table, so I don't want to forget.
Okay, fine. My bad.
Responding in patches. All right. So you mentioned about those things. Let us not use conjecture. So the things that we don't know of has to be left out of the conversation. Would you agree? Because all of that would be assumption thereafter.
No, anything I just shared a while ago wouldn't be assumption.
No. All right.
Declaring what is not in the case.
All right.
Yes.
So let us look at one thing that we would have to assume that it either happened or didn't happen. Right? You said you have no proof of a check. So we are going into the realms of conjecture when we begin to step.
That's not conjecture, Joshua. There is no proof of a check in any of the documents.
And there is not a proof that it wasn't paid either.
No, but Joshua, come on now. If you're gonna make a sale, then you have to have proof of a payment for the purchase.
All right. So let me ask you a question. 1967 to now, that is 59 years ago, almost 60 years ago, right? What it means is that because this land has been in this between sale and dispute until now, we would have gone through several luminaries within Jamaica. Would you agree on that?
Several what?
Luminaries, legal people, legal luminaries, lawyers, judges, and these people. Would you agree on that? All right. If that is the case, has Jamaica, over the period of time, over the 6 decades in question, has a rich history of legal practices? Or at least standout legal personnel? Would you say that?
That it has a rich history of what?
Legal practitioners. The Bert Samuels, the PJ Patterson, Bobby Pickers.
I would say we have a history of some good ones and we have a history of some very bad ones.
All right. So at the senior level where the judge on the judge's bench is, by and large, we have had a good record, right?
I can't agree there.
Do you have anything contrary to that to present then?
The entire Castle case would be my easiest example to refer to. That was a complete botch on the entire justice system that we have.
All right. Is that normal? Yeah. That is why I use the term by and large. Is that normal or is this so?
Is it normal for things to get through the court that shouldn't get through?
My brother. That is why we have appellate courts in every jurisdiction. It is not unique to Jamaica. Because it is understood.
Why we have the Privy Council, because
hold on, my friend. I am not going outside of the realm of Jamaica yet. In every jurisdiction, the United States, Europe, Asia, we have an appellate court. We even have the International Criminal Court and all of these things. Right? So what it means is that it is understood that once you're dealing with law, it is subjected to interpretation sometimes. Would you agree on that?
Yes.
Right, and if it's subjected to interpretation and we're dealing with flawed human beings, then there are times we're going to get it wrong. But there is recourse in law when you can take it to the Supreme Court and then afterwards to the appellate court, which is the final court in the local land. Right? Right, sir? Is that correct? Jordan?
I didn't realize somebody muted me. But yeah, so that's why my recommendation from the get-go was where it concerns the people on the land.
No.
I would be applying
No, we're not there yet. We're trying to iron out something before we get to the people. I am saying, and I'm asking this question because you said that you can cite a most recent case. So the point that I'm trying to make, the broader point, is that you are not going to have a perfect system. So even if you have a 20% or 25%,
that doesn't mean I don't demand one, though.
I wasn't suggesting that either. But I'm saying even if you have a 20% or 25% rate that isn't good, you have a 75% in favor of proper practice, legal practice, right? Which means that by and large, we would have been adhering to the principles thereof, right? And Jamaica...
I don't analyze things that way. I get what you're saying, and I get you when you say 75%.
So metrics and data isn't important to you then?
No, it's not about metrics and data not being important, but 25% of cases not going well is a blasphemy on our justice system. There's no other way I can.
I am not saying that that is the case in
It has to be
Jamaica.
99% going well,
my brother,
and 1% maybe not going well. Then maybe I can work with it.
My brother, no system in the world has a 1% rate.
My fairy tale system does, though, and that's what I work with. I don't work with
that is exactly why you shouldn't be in the real world. One moment, Philippians.
No, guys. Unless we're going to pay my taxes, then we have no ability to decide what I should have as a standard or not. So let's leave that
Jordan, if we are going to use your line of reasoning about in your fairy tale world, that it doesn't work that way, then you shouldn't be in the real world arguing with real people. You should continue to live in La La Land.
Well, until the real people pay my taxes, they don't really get to determine how I view things.
No,
right?
but you said in your fairy tale world, which means that it's intangible world. It's an intangible world.
I get what you're trying to do here, but let's just be clear on
what
something.
am I trying to do? To bring truth to
No,
power?
you haven't shared any truth here, to be honest, Joshua. This hasn't been a conversation about truth. What you're trying to do, which I get it, is that you're trying to break it down to suggest that, okay, nothing more could be done about this situation. And that's your view. But I believe otherwise.
My brother, all the systems have been exhausted. And you, by your own reference, says that in your own fairy tale world. You know, up until then.
No, but I'm saying that because I know everybody's going to say,
Can I get my question in?
I'm going to yield here now, Lionheart. But up until that point, we were still playing good cricket. But right there,
but I don't wrong you, Joshua. And it's not that I'm denying your points. What I'm trying to get across is my viewpoint of the overall situation is that a lot has happened that does not seem correct by law, at least by the laws that they tell us. And then a lot has also been missing. So in terms of, I've tried to get certain information and I have to be filling in blanks where technically, if everything went smoothly and this was done properly, you wouldn't really have such difficulty
So Crosskill, Mr. Richard, I beg you one more go.
Yeah, that's fine.
You know, a while ago I mentioned about conjecture, which means that we would be working by assumptions. And you said, no, that wasn't the case. But you have now come full circle and you said, you now have to be filling in blanks.
Concluding that there's a check. No, because what I'm saying is me concluding that there's a check that wasn't confirmed to have been paid to Jobson.
Right.
That's not an assumption. That's a conclusion.
And we have nothing else to the contrary either. That it wasn't paid.
That's a conclusion, Joshua. So
and that's a flawed conclusion.
In a court of law, they should have been required to prove that.
But in a court of law, what you're presenting is hearsay.
No, Joshua. Listen to what I just said. Joshua. If I pay you some money and I have declared in court that I paid you some money, what should have happened then is that the Administrator General should have said, okay, well, show me where that payment went to Jobson.
But, sir,
Administrator General seemingly did not do that.
I am sure that they have other means, right? Even under the same.
I'm working with what I have. I'm not working with what other means.
I am now introducing something else. I am now introducing something else that shows you that even the very approach that you're taking is flawed. Because under the same adverse possession law, previously it was 7 years. So even if it's by adverse possession in 1967, it would have been legally being owned by that person in 1967. So your argument is
wait. Where do you have proof that New Falmouth took full possession from 67, go straight to 80 when the man died?
And where do we have proof that they didn't?
But Joshua, that's kind of my point. All I'm trying to do is get to the full truth. You guys are trying to stop us from even getting to the full truth.
No one is trying to stop you, sir. All we're saying is that you're running on a wild
what I'm suggesting is by not asking
one moment, let me finish, Crosskill. All we're saying is that you're chasing a phantom.
But if that's what you believe or if that's what your viewpoint is, I don't really have a bother with that. That's not my business.
You know, it is your business. The fact that you're engaging in a conversation regarding the matter, then you have a duty of responsibility to put the truth and the facts on the table. And I yield there. Richard, over to you. Cross skills.
No,
Thank you, sir.
Joshua.
My question to you, though, Jordan.
Story or level of
are you going to listen?
Then yeah, I will listen, but I just want to respond to that last part from Joshua. I get what you're saying, Joshua, and I don't necessarily disagree completely. What I'm trying to say to you is, if a story does not fit up to me, if pieces of it are all over here, there, and wherever, then how I look at things and how I deal with things is that I go from the core, the root issue. I go on, I ask as many questions as I can. I try and find as much information as I can. I don't care if anybody likes the questions or don't like it. I don't care if they're political to you or not. My view, my way of handling things is never going to be yours, nor is yours going to be mine.
I will agree with you on that. I will agree with you on that regard. You see,
then we're fine.
I will agree with you in that regard, but my parting shot to you, one of the most famous cases in Jamaica in most recent time, because you did say that if it doesn't fit, right? Which means that you're going to have one perspective, I'm going to have another, right? But one of the most famous cases in Jamaica is the entertainer that went
Joshua, hold on there, Joshua. Say me can't believe me drop asleep with the live here, almost 500 people. I want to make Jordan come up here. Come up here. Give me all a sit. To me, all the cash and don't a request.
It's not Jordan that brought it down. It's not Jordan that brought it down. When he came up with
Petal, more and talk to him to Petal. More and talk to him. Him done there already.
Hold on,
to Jordan boat.
Hold on, sweetie.
Hi, Petal. Hi.
Calm down for Joshua. Calm down for Joshua. I'll lend you my heart so that you can use it.
Because no, have this boy over here making
Petal.
Hold on,
Petal. More and chat to Petal. More and chat to him to Petal. Just hold on.
Okay, let me ask my question now.
One of the most famous cases in recent time is the one with Adidja Palmer. In spite of the result, there are both sides, and those two sides will always contend. But the case was not thrown out because of guilt or innocence, but merely because of how it was handled. What am I saying? That
technical default, Joshua.
Right. You having a divergent view doesn't make your opinion correct. Right? We can always feel how we feel, but the evidence is what matters. And that's all I'm harping on, the evidence before us. Our feelings are immaterial when it comes to litigation. And I yield right there. Thank you for your time, Jordan.
Yes, my question here, Jordan. If you think the people there have been wronged, shouldn't they go and report it to the police, get the statement, and then seek legal advice?
If they should report it to the police.
No, if you think the people, what was done to the people was wrong, shouldn't they go and report it to the police, get the statement from the police, and get a lawyer on the case?
Yes, I think that's what Mark and them were suggesting them to do.
Yes, but how can they do that when they were given the go-ahead to get off the land and to pay penalty because of squatting?
Huh?
How could they do that when they were charged? The judge told them that they have to pay 50,000 for penalty for squatting on the land. The court gave the owner the okay.
What was the year date?
Pardon me?
What was the year when the judge said that?
But if you were following this case, you would have to ask me that question.
No, man. The reason why I'm asking you that is because I know that the judge did not ask that within the last 10 years, which means that there's a good chance some of the people
is, if you were following the case, you would not ask that
question. The ones responsible there. So, yes, I get what you're asking, but I'm saying to you that what you would have to do now, if you're suggesting that the court require those people to pay, they would have to then follow up on that court order and demand that the people pay.
I want to ask something, guys. Who accepted Jordan up in the line?
Who received
I don't know. I don't, for the life of me, I don't know.
The host himself.
Why not do that?
Guys,
when Jordan turned on his light,
don't bother with that.
People over here.
Don't bother with that kind of behavior.
Who said that about behavior?
Don't bother with that kind of behavior.
We're going to bother with it. I was on Munchie Life and Jordan tell me to suck my mother for no reason. So why Jordan up here?
Jordan up here. Enough going to people mother, so.
DP, what, you sure it was for no reason?
When Jordan have his
there shouldn't be enough reason for you to go on people's clothes. There shouldn't be enough reason for you to go on people's clothes, sir. You need to respect.
Why you want to determine what my
this is what I said, Joshua. Either on a labor rights board or something. There's absolutely no reason to Jordan up here. What the hell?
Them something there.
What the hell?
Him mother, I know going to tell DP to go on that mother.
This man tell me to suck my mother for Munchie Life last week Sunday for no reason. No reason. And I say anytime I see him pound alive, that never come say. No reason. Luckily, I think that Knox they drop him. We are talking thing and him just
the quorum. We can't.
No, my boy, me sure I know a reason.
Wait no man, my finger nimbling. I'm mad to take him down, you know. But because Jordan attacked him, I don't know. Either on the board labor rights because I don't know what the hell. I don't know what the hell. What do you expect to get out of Jordan? What do you expect to get out of Jordan?
What did I do or say, Petal? What did I do or say for Jordan? Tell me something, man. No, he must say me sure it was for no reason. So that means he admit it.
Actually, I am the one who went up in the box and me say to them, me telling you otherwise if you stop entertaining Jordan and me talk and I think you come up and you must say you agree.
Remember
and as soon as you open
Munchie, yes, you remember when Munchie said you have 200 and something followers and I said if I use way to gain followers. Because when we just hear about him at 97 alone, he may never know him at 200. So that's him tell me, Philip.
He said you're Philippian. First of all, we have so much recording to play about the Trillani is something. We have George sitting to play. We have Emily sitting can play over, make people sit down and listen and understand and go through it. We can really waste the time and chat to a mad boy.
Learn nothing from him. Nothing I learn from him.
All right, Petal. My DP go at it. Petal, you know something so like when you behave that way, right?
Me say, Josh, no, you hear my ask a while ago, so that means I admit.
King.
And all it was, I was saying, Munchie said, say, he might use the platform for build fame. Although he can't get more than 8 people when he open live. And that is the facts I was stating that when I just heard about Jordan, he only had 97 followers. And she's almost 200. She now waste no time with him because 200 him have. So I never repeat and that him tell me for something, motherfucker. And now I say, if me sure I say it was for nothing.
Every night him give me invite. Every night him. Sometimes I wonder if him not sleep. Every
sleep
night.
at night time. When you
wake up, I don't use you. Why would I use you guys for anything?
6 people in afternoon live. 6 people. 7 maximum. Okay?
Him not sleep,
turn on in live.
Him not sleep.
Not even PNP then now go up on the night time. Go give a number.
Me not like you. Me not like you, the boy, no man. Me not even vice. Me not like you.
Yeah, but you drugs, bro. Yo,
he might do drugs. He might do drugs.
You say me look at me say you down there. Look to go up in the box. Me say I don't take him up. Take him down and me
try to pause you from getting possession of the land and sought an injunction against New Falmouth to stop New Falmouth and people. The court the basis on which the Minister of Housing at the time sought to get a stay and to get an injunction against New Falmouth was that the minister, after New Falmouth won in the court, the minister claimed that he declared the land to be improvement area on the Housing Act, and so he was at liberty to take over the land compulsorily. And a number of affidavits were put in. New Falmouth resisted the application, told the court of the history of the matter. And in fact, when the Minister of Housing's application went before the court, one judge heard the application, hearing only the minister's side, which is called the ex parte application, and granted the Minister of Housing an interim stay for 30 days rather, and set the application to be heard with both parties present at a later date. When the matter went at a later date with the two parties as the Minister of Housing and New Falmouth before another judge, the judge heard the application and the judge granted an order restraining in 2012 New Falmouth from interfering with the 99 people against whom the application was initially brought by New Falmouth. Then now, later on, in the application, another application for stay of execution, and after hearing submissions from counsel for the parties, one of the judges adjourned the matter and requested either the minister or one of the people who filed an affidavit to appear. According to this history of the matter that the Honorable Mr. Justice Frank Williams gave in the Court of Appeal case, he said on the 4th of May, Justice McIntosh delivered his decision dismissing the application which was brought by the Minister of Housing. The judge says neither the minister nor Shukir appeared in court. However, the learned judge recognized the presence of officers of the Housing Agency of Jamaica, Mrs. Simone Morris Rattray and Mrs. Janice Buchanan McLean, and handed them a copy of the orders which he'd made. There was no appeal from the learned judge's decision. The reasons for the learned judge's decision were contained in the formal order filed on the 18th of May 2012. And this is what the judge wrote in the formal order. It is clear from the application to stay execution, so this is when now the Minister of Housing applied to halt New Falmouth taking possession, and the court denied the minister's application. These are the reasons the judge has put out in the order. Let me take a break and come back. The Jamaica Civil Service Association.
Good of our nation.
Short break. She'll be back in a minute.
So this is what the Court of Appeal recites as the reasons Justice McIntosh dismissed the Minister of Housing's application for a stay of a judgment previously given in favor of New Falmouth. And the court also dismissed the Minister of Housing's application for an injunction to stop New Falmouth from removing the residents from 2010. This is what the judge said. It is clear from the application to stay that it is intended to be an indefinite one, as there is no indication of a date or period for allowing the claimants to have the fruits of the judgment or award handed down in their favor. In other words, whatever it is the Minister of Housing said it was intending to do, there was no period by which it was indicated it's going to be done. And that indefinite nature, it allowed for some vacillation, some uncertainty about by when New Falmouth could have the benefit of the judgment that New Falmouth had. 2, the presence of legal officers from the housing agency may be intended to suggest to the court that the government is taking actual and immediate steps to assist the parties in mutually beneficial settlement. 3, actually this is stated as 5, so it's 3, 4, 5. I suppose 1 and 2 were not that material, so the Court of Appeal judge didn't cite them. Given the history of this case, the length of the trial, and the efforts made by the court to assist the defendants there are the people who possess the land. Let me read it again. This is what the judge said. Given the history of the case, the length of the trial, and the efforts made by the court to assist the defendants who seem to have been misled by politicians into squatting on private property, notwithstanding their unlawful act. This court empathizes with the gullible defendants. 6, the application, this is an application by the Minister of Housing to stay the order of the court, which was granted in favor of New Falmouth, and the application for injunction. The court said the application is iniquitous. That means it is grossly unfair, it is morally wrong, it is wicked, it is unjust. This is what the court said. This is not the first judge, this is not the second judge, and this is not the third judge reciting the facts. It's judge on top of judge on top of judge. The judge continues. It may be that the law is not a shackle to the lawmakers. That does not apply to the court, which must dispense justice according to the law. 7, it is the court's view that the application is devoid of sincerity. It is an attempt to pervert the course of justice and an abuse of the process of the court. This is what the court is saying to the Minister of Housing based on its application to stall a judgment that was given to New Falmouth years before. The application is refused with costs. So they're supposed to pay the cost for New Falmouth. And as I told you, when you read the affidavit of Mr. Chisholm is telling them from 2002, he went to every agency begging them, please help, please find somewhere to put these people. I need my land, I need this, I need that. Not one soul batted an eyelid. The court accepted that as fact, because anybody can say anything in affidavit, but for the court to accept it, it went through a process of examination, cross-examination, passed the test of admissibility, passed the test of hearsay, and the court accepted it. Right? So the court granted the Minister of Housing leave to appeal. Then on the 1st of May 2012, the minister lodged a caveat against a certificate of title for the land and gazetted notice of the subject land being declared to be an improvement area pursuant to Section 6 of the Housing Act, published in the Jamaica Gazette. So I heard Mr. Cousins yesterday talking about the gazetting. And when you look on the face of the title, it is there, gazetted. But there's a backstory behind it, and this decision outlines for you where it is. 131. In fact, I don't even know. Something else must have happened because I don't know how this caveat remains on the title with this particular decision of the court. It must have lapsed, or it should have been removed by some means, unless there is an intervening court action that has caused it to stay. So if you look on the title and you see this caveat, which is actually lodged the 1st of May, you may think that the Minister of Housing is properly entitled to some sort of equitable interest in the property. But based on this decision, which they appealed and lost, there could be no such entitlement to the maintaining of a caveat on New Falmouth's property, unless there's something I'm missing. So the court then goes now to the, after they lodged the caveat, they filed another claim in the court, a separate action now in 2012, a fixed date claim, where they sought several declarations, and that's part of what I took you to, including one that they were entitled to compulsory take over the land. They filed a notice of for injunction, fixed date claim form supported by affidavit, Morris Ratchery, and it goes on. New Falmouth's lawyers, in response to the application filed by the minister, they filed an application for court orders, seeking as a matter of to strike out the minister's application on the ground application was an abuse of the process of the court, and it was really in substance the same relief that were sought under the other claim. Right? So all of the things I read to you before sound familiar, because what they did in 2012 was to file a new claim where they were seeking sort of the same remedy. And so on the 21st of May, Justice Harris, then acting after hearing submissions of counsel, ordered by consent that New Falmouth and its agents be restrained from dealing with the land and from interfering with the occupants without the consent of the minister until the 7th of June 2012. So the matter was adjourned to that date to be heard. And the matter then went before Justice Campbell on the 21st of May 2013, continued over several months, at the end of which Justice Campbell ruled that the application before the court, which was brought by the Minister of Housing, was an abuse of the process. And so it dismissed the Minister of Housing applications and made the orders which I read to you earlier on in my views. So this is probably now the third, maybe fourth decision in favor of New Falmouth before 5 different judges. A couple of them granted interim injunction, a couple of them after inter partes hearing granted injunction by consent. But every step of the way, New Falmouth was policing the matter, begging for help. No government agency helped. Then the minister came and sought to do executive action, then applied to the court. The court said, no, you cannot usurp the function of the court. You cannot do something that the court has already ordered is to be done, and you haven't appealed that decision. We're going to stop it. And they appealed to the Court of Appeal. When they appealed to the Court of Appeal, these are the grounds that they appealed. They wanted the court to say that the judge, this is Justice Campbell now, misdirected himself in fact and law when he found that the alleged purpose of the minister is not for general interest of the community, but merely for private individuals voluntarily associated together for their own benefit. They say the learned judge, Justice Campbell, in finding that there's no public purpose to the compulsory acquisition, failed to appreciate that definition of public purpose would take into account the benefits that would redound to the community as a whole, and in so doing, they're saying the learned judge misconstrued the provision and the intent of Section 25 of the Housing Act. They also sought from the court agreement to say that the learned judge misconstrued the meaning of Section 25 of the Act and exceeded its jurisdiction by exercising a discretion reserved for the minister. They say they wanted the Court of Appeal to hold that Justice Campbell failed to appreciate and or misdirected himself in law when he found that the principles of res judicata and abuse of process were relevant to the proceedings before him. In other words, the matter tried already for the same thing, and you can't come back and repeat them here in the subsequent thing. They wanted the Court of Appeal to say that the judge, Justice Campbell, erred in fact and misdirected himself in law when he found that the relief sought in both claims.
Mute a second. The Prime Minister answer.
PM answered?
Eh?
The PM answered?
It's him not in detail. Him say him plan to address it.
I know, PM never have to tell me that.
And him just like choose so much legal matters involved. He might get the proper information first before him get legal advice and proper information before he come forward.
As we respect the Prime Minister too.
Was the acquisition of the subject land. They wanted the Court of Appeal to also say that the judge erred in law when he found that the identification of public law issues is insufficient answer to New Falmouth's argument that the issues have been ventilated before the court. And so they lay out about 10 different grounds of appeal that they were challenging Justice Campbell's decision on. And a panel of 3 judges, Justice Phillips, Justice of Appeal Brooks, so these are all appeal judges, and Frank Williams, heard the Minister of Housing's appeal. This was heard October 2025 and April 2015 and April 2016. And on all of the points that they argued, those points of appeal that I mentioned to you, some of them that I read to you, the Court of Appeal concluded, in light of their analysis, I am unable to say that the learned judge, this is Justice Campbell, fell into error in his overall analysis and treatment of the issues in this case. The later claim, which is the one that the minister filed by a fixed date claim form, having been in substance the same as the earlier claim and appearing to have the effect of attempting to circumvent the orders of Justice McIntosh, they clearly amounted to an abuse of the process of the court. That fact, coupled with the minister's failure to demonstrate compliance with the requirements of Section 6 of the Act, helped to seal the fate of his applications. In these circumstances, it could not fairly be said that the learned judge was palpably wrong. I am therefore of the view that the appeal ought to be dismissed with cost to the respondent, that is New Falmouth, to be agreed or taxed. 3 judges, unanimous decision, 20 I'm up on a break. You're tuned to Radio Jamaica Effective now. So
far, that is 3 judges will rule with cost to the people. Them say, no waste the people them time. Pay them good cost.
Yeah, so
this is the appellate court as well.
Yeah?
This is the appellate court as well. It's not a local parish court.
Right. And all of them rule. These people want the place, no waste the people them time, so pay them costs.
I'm sure there are probably more matters. I've been trying to reach Counsel Juliet Mayor-Rose without success because I see her as a common, one of the counsel appearing in multiple matters for New Falmouth. If anybody knows Counsel Mrs. Mayor-Rose and if you can get a message to her, please tell her I'm desperately trying to reach her because it seems to me that every single thing.
The Minister of Housing then was Dr. Guy, Maurice Guy.
That was legally desirable, possible, procedurally correct in seeking to have the court declare who is the owner of the land, having had the declaration, having the court order possession of the land, and then resisting what I consider, forget my consideration, I accept the words of 2 judges of the Supreme Court, the iniquitous application by the Minister of Housing. And I tell you, this is part of the challenge that goes on for me, you know. You have these guys who talk about judicial independence. The court assessed based on evidence before it People subject to cross-examination. Submissions in law went before the court. After years of pleadings being filed the court, after months of trial before the court, and the tribunal of fact assessed credibility. Look at the cogency of the matter in law and came to a decision. And a member of the executive turned around and declared the area over which the court made an order to be an area that it can compulsorily acquire with the intention of thwarting the decision of the court, put a caveat on the title, gazette its action, then turn around and sue the man who got the decision and try to get an injunction against the man. The man challenges it. And when the man challenges it, another panel heard all of the arguments and stopped the minister and said, no, what you're coming with, we've already heard and decided it, and your application is ungodly, unworthy, it is wicked. And what is happening is that you, the politicians, have made the people believe that it is okay for them to stay here and to consistently and constantly deprive the registered title holder of his interest in the land. That is not right. That is not constitutional. That is not legal. No. And they challenge it to the Court of Appeal. 3 judges at the Court of Appeal unanimously said, the judge, I cannot find any way to say that the judge is wrong. So you, minister, you lose. Not only have you lost, you need to pay New Falmouth's lawyers their cost of the appeal here and below. Yeah? And I hear people now telling the government that they must take action akin to what the Minister of Housing did in 2012, which the court has already frowned upon and labeled it as iniquitous. So the question is, do you think that any litigant who has so prosecuted this matter over nearly 20 years in the court, brought his action, resisted adverse applications, consented to interim injunction until things are settled, you think that those people would not seek to ensure that they do enforcement according to law? So when I hear the story, the first thing I'm saying, but police can't just go so. Was there a bailiff involved? There must be a bailiff involved. So yesterday, I'm making all of the inquiries the day before. Was the bailiff involved? Before the bailiff, is there a writ of possession? Because as I said to you, even though these orders were formed in the court, New Falmouth has to go a step further. When they serve the order on the people, some people might move, some people might not move. And for those who have not moved, they have to go back to the court and make an application to ask the court to please issue a writ of possession because they still have not been able to benefit from the fruit of the order. So I got a copy of the order yesterday.
Come back, Emily.
And apparently there was a hearing on the 19th of May 2026 based on an application which was filed on the 30th of March 2026. So on the 19th of May, after the judge heard the attorney for New Falmouth the judge granted the orders which were sought in the notice of application. There are 1, 2, 3, 4, 5 pages of defendants. So it's between New Falmouth and 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 99 or more different people as defendants. And this went before another judge. And for the judge to have granted the order for the reissuing of a writ of possession, the attorney needed to have satisfied the judge that all other orders in relation to this matter, they'd been served. And when the judge is satisfied, then the judge can go to the reissue. I don't know when the first one was issued. That I'd like to know, because part of what I don't understand is what happened in sort of that interregnum between the Court of Appeal decision and this application for the reissuing of the writ. But as I've explained, it is when the attorney has a writ of possession that the attorney goes to then writing to the bailiff to prepare for the bailiff a sealed copy of the order so the bailiff can feel the seal of the court on it. Engage the bailiff, settle whatever fees. The bailiff gets in touch with the police. The bailiff doesn't deal with service of papers. The bailiff comes in because papers were already served. The court was satisfied that the papers were served, hence the writ of possession has been granted, and the bailiff goes in. If it's a levy, it's a warrant for levy, then the bailiff needs permission. But if it is for possession, no permission is needed. The bailiff goes, the bailiff will take out whatever is in the house, take them off the owner's property, and the bailiff's role based on the order of the court is to remove whatever is there by whatever means necessary, because the people have already been notified, must have been notified that at some point in time, you've lost the right to be here. Not right. You've lost the chance to be here. So that's how I know that it works from start to finish. I've been trying to reach the High Command, spoke with a member of the High Command yesterday, spoke with the Minister of National Security to get some more information, because yesterday John called to say he understands that police detained young men, took them out before the operation and then took them back. All of that information, I need to understand what happened. Is it that operation, the pre-dawn operation, is it one and the same as the demolition action? And if so, how come? Because the police who go with the bailiff are not police who would be arresting young people or old people. They sort of go there just to keep the peace. That's why you engage them. Sometimes you send people to go feed the land, and when you realize that it is potentially dangerous, even the bailiff say to you, we are going to need to have police presence there to make sure everything is okay. But those police invariably are not police who are detaining young men. So something seems amiss to me based on how I know that these things are supposed to work, which is why I'm asking for the High Command to say, what is this pre-dawn operation that took place? Is it connected with the bailiff and the police going there? And if it is separate, how can it be so coincidental? Yeah. So before I come to
Yes, Erica, they can arrest if things get out of hand, but that's what they're for.
Anything else? There are a lot of things that have to be satisfied in my head. And all the other question to ask is, really, what does a registered proprietor of land who has done all of these things, what else does he do? What else? I mean, when I look and I see that a young lady, they say, was put out in the bus stop, dreadfully awful scenes. But also the mere fact that a new generation is coming is indication that New Falmouth was never gonna get the fruit of its judgment. So, just what happens?
For the good of our nation.
I continue to see who we can get from the High Command. Nobody has responded yet. And also trying to reach Council Juliet Mayor Rose, who is one of the attorneys who appeared before the court in late 2007 and subsequent applications, and also in the application for the reissuing of the writ of possession. I need to check on the something related to that date. Let me come to your calls though. 876 9262178, 9268631, 9267615, 888-991-2080. Let's see. So,
hey, a long time hotline had a number there, no?
So this order was made in May. It looks like it was filed in August. It went before the judge.
The men were detained, not arrested. Detained, but the police has said it was a totally different operation from the evacuation.
And Chuck. On the 19th of May.
This is different from the eviction. Sorry, different from the eviction.
Chuck, that did have to go on because maybe them man there would retaliate and harm the man them will operate.
That part didn't matter. The police said it was a total different operation. That operation was planned long before that they were gonna go in and look for some men of interest. Totally different operation.
The hotline. Morning.
Hi, good morning, Mr. Shields.
John.
You know, I see something here from the principals and vice principals of schools. It's saying that the charge of teacher is becoming a crisis. You know.
And listen to John. I was to play. Judge Davis. Judge Davis spoke about the two different operations. So I'm not gonna hear Judge Davis side of it now. Yeah, I can't listen to people like John. John them not nothing to contribute to nation building.
So Chuck, hold on this. What you say? The man them were them detained.
It's hard to believe that in the middle of record
police have them under suspicion hour.
Yes. Police had an operation planned, and that was probably just somebody take advantage of the timing.
Okay.
To be kept together.
Okay.
Any other way, I'm sorry.
Some of them man in the street, you know.
And listening chronological is not the right word. Way of how the people who own that land try to keep that land.
That's not the one I'm looking for. Sorry, that's not the one I want. I want the one I must speak this morning. This one.
Right. Way of how the
that's
people
not
who
it.
own that land.
This is
notice. Since this issue Meadows doesn't say, or perhaps he expects us to take as given, that the perspective he has given is a legal opinion, one.
Just a minute, just Joshua.
Let me stay there first. Because if it's a legal opinion, we all know that doesn't make it sound, because you can have 50 trillion legal opinions. Which of them will be upheld by a court is another matter entirely, but is it a legal opinion? One. And then two, if it is that I own land, that there's a caveat on, following Dennis Meadows' reasoning. If I own land as a private developer or a private citizen, and the government has a caveat on that land, and Dennis Meadows is saying, based on the strength of the caveat, the government can do certain things with the land. What would prevent me as a private owner from also doing certain things with the land? And if, as his statement is suggesting, those things that the government can do with the land through its caveat doesn't necessarily involve the input of the private developer, or can act outside the wishes of the private owner because of that caveat, why can the private owner not act outside of what the caveat says and perhaps gives the government the power to do? Is what I'm saying. So the statement is necessary to publish, because it groans again on what basis is the opposition calling on the Minister of Housing to act. We've seen that clearly. So we've seen what they say informs their perspective about the course of action that should be taken. But then that course of action or that basis has to be interrogated. Is the plinth solid? And the very few questions I've asked so far strike at the heart of that. What is the effect of the government having a caveat on land that I own? And what gives a government the right to act based on the strength of that caveat, but at the same time ties my hands from doing what I want to do with my land?
Kerry, may I go do a better recording of that Emily one without the humming here? May I go do a better one and then send it to you?
So these are the questions that must be answered, because the fact of a caveat and the opinion by Dennis Meadows do not by themselves mean that the private owner's interests are ancillary or subsidiary to the actions and the potential actions of any government. That's just my view. And, you know, they say opinions are like, you know, where everybody has one. Legal opinions are of a higher level, but, you know, lawyers differ. So there you go. And then, of course, it goes to an independent arbiter, independent finder of fact, to settle the matter one way or the other. But that's just something to consider. On the point of the detention, you know, that troubled me from the start. But if you notice, since this issue became hot button, I have said nothing publicly about the detention of the men. I've seen videos with a man who represents himself in the video as an attorney. I don't know if he is, so I'm not trying to throw shade on him or anything. I wouldn't do that to an attorney at law or any professional for that matter. It's bad form. I'm a human being, and respect is the least I can give. It costs me nothing, so I wouldn't do that. But I don't know if he is. I didn't see a name either, so I couldn't ask someone if this gentleman is a lawyer. But in the video, he represented himself as if he was an attorney, and he was with a group of men who were giving accounts of being detained in Cooper's Pen and moved before the demolition happened. Now, what I have said this week is that men were moved out, and I pursued the line of argument to say, well, if people don't believe, if it went like that, that the detention of men who would perhaps provide resistance to attempts to clear the land, if that wasn't a smart thing to do to de-escalate the situation or to remove agents of escalation from the community, so that the work of the demolition crew, supervised by the security forces, could happen. I did go along with that line, but I didn't comment on the specific matter of the detention itself because in my mind, there were questions I needed answered. Yesterday, an eminent journalist called to ask, George, is this really so? And I said, this is a spark to check further. So when I checked, this is what I was made to understand. And again, it's the account that I've been given, I'm sharing with you. It is my understanding that two things happened in Cooper's Pen on Tuesday morning. One, the police conducted an operation between about 1 a.m. and about 4 a.m. That operation was for persons of interest, or stronger than that, suspects in criminal matters, and that several men were detained. As I've said on this program, Cooper's Pen is somewhere I know rather well. I have family there, so it's not somewhere I have to ask someone about the nature of the community or wherever or whatever. Yeah, I've known about Cooper's Pen from Cooper's Pen was where the people left from to go work at the then Trelawney Beach Hotel. At time, a little boy, as country people would say, a little boy, for my friends who are not at home with the vernacular. Yeah? Trelawney Beach Hotel. So anybody who knows, say, Trelawney Beach Hotel a long time. But yeah, that's how long I've known of Cooper's Pen, family there, as I've said. So I know the nature of the community. Yeah, it's not a teddy bear community. Okay? Good. So the police operation there for those between 1 and 4 a.m., that happened. I'm being told that the demolition crew with their court supervisor, because that's how the process has to work, and the police came after 6. So I said, So I said, hold on. But the residents say that the demolition crew with the tractors came before dawn, pre-dawn. 6 a.m. is not pre-dawn.
Thank you, Chief.
6 a.m. sun hot out to do. But the residents say, yeah man, from 3 o'clock. So I've heard people say from 3 a.m. the tractor them come. And I said, no, the tractors couldn't have come at 3 a.m. because based on how the law works, you can't do something like that outside of the hours where the court-approved person to supervise the demolition, a court-appointed person to supervise the demolition, is available. And who's going to get out of them bed before they to come and do something like that? They come early because of the likelihood that, it won't create a traffic snarl depending on where the demolition is taking place. The opportunity for violence and bad blood, you do it early, and you try to get out before things get really hot, literally and figuratively. So I'm told, and I'm sharing with you, I'm not telling you that you must believe it. It was said to me by people who I trust and have confidence in, and I'm sharing it with you. But as ever, you weigh and balance it yourself. So one police operation, different team unconnected to the demolition people, came and did, as part of their coordinated search and operation, they went in, they detained. So I'm being told that it has nothing to do with the demolition team which came after 6. And the narrative that men were taken out strategically so that they wouldn't be in Cooper's Pen when the demolition crew came and picked up. I'm told that no, absolutely not. Nonsense. I'm being told that it was purely coincidental. So I said, They said, well, yes. And I checked further. In media, you get information from one source. You come 1, 2, 3 more. Satisfy yourself. If the information bears out, you can go forward and you can articulate publicly. And that's what I was told. So that stands on one side, and on the other side is the claim from people in the community on the ground, members of the opposition as well, that the men were strategically taken out and detained against their will, and they were released conveniently after the demolition exercise had run its course.
You see, user, here is my take.
My information.
Here's my take on the thing. The bailiff would have received the orders. He would have gone to the police and said, we're going to go around this community and we're going to need police protection. The police would have said, well, we have an operation plan on there for next week, Tuesday, where we're going to go look for some wanted men. The bailiff would have said, okay, then I'm going to piggyback on that. That is one scenario. I'm not saying that's what happened. I'm not saying that is what happened, but that's a possibility. Right? That is a possibility. So we can come now and listen to a man and tell you what his investigation told him. That says, listen, this is two different operations. One didn't have anything to do with the other. I have to say a crap. My take is simple. If you have evidence to the contrary, present it in America.
Okay.
Yeah.
You know, one thing as I get older, I'm learning that a lot of persons are not interested in truth enough. What they're interested in is what satisfies either their emotions or the narrative that they want to spew. So if their emotions tell them that this is so, in spite of what is presented that goes contrary to it, they hang on to the emotion. Or if they are putting forward a narrative and something comes that is contrary to the narrative,
you will be missed.
I've learned that people know sometimes with diamond and character for them. By the way, you had played something, even though you cut it off abruptly, you would have seen me send you the information on it. When comrades want to give the impression that Jamaica is falling apart and we don't have no teachers, because of the way the government treat teachers, that's not the case. In economics, they talk about the law of supply and demand. Now, the United States has a 12.5% shortage of teachers, which works out to just under 250,000, 425,000 teachers short within their education system. And this is an institute, the Education Institute, that measures this kind of information. So, the comrades can always be disproved with the lies that they put forward, with simple facts. And I just wanted to put that out there. And for those who are talking about down in the country, in as much as the people brought a law, the Ministry of Labor and Social Security has gone down there and has been giving assistance, and prior to that, had gone down there and gave some level of assistance. So this thing was not done in spite of the fact that the government had nothing to do with it initially. The government has stepped in and is stepping in to do something. So when Mark Golding tries to pat himself on the back and on the shoulder as if he's doing this great deal and he's the one who is lobbying on behalf of the people, there's a difference between lobbying and politicization of a matter. And Mark Golding is really politicizing it. He's doing nothing. All right, I yield right there, Chucky.
Yes, sir. Connect in the dot. Since I hear from you, my friend.
Brother, good afternoon, everybody.
Good man.
Yes, man. Blessings.
Connecting, how you doing, sir?
Yeah, man. Everybody, a long time. I'm here. That tape, Emily, she state that you played here. I'm going to make a suggestion. Is it Emily? Emily is a very... Just a mute the mic. Mute the mic, Josh.
Oh, sorry.
Yeah, man. Emily is a very brilliant journalist. But she's also a lawyer. A practicing lawyer. So if you realize, she was able to delve into the case, and she knows what to look for and what to or to investigate with her journalism background and her legal mind. She's very, very good at this.
Guys, if you're interested, George is doing a special edition, and he has Saeed, who works at Nationwide.
So it's a registered land.
Okay.
The volume and folio. The subject
And
matter
divided.
1008, volume 4636. And the registered proprietor is New Falmouth Resorts Limited, which is a company registered under the laws of Jamaica. And the chairman and chief executive officer is Mr. James Chisholm. And the information that I have here, that I have gleaned, is from my meticulous reading of both cases. And that's the case in the Supreme Court, the Court of Appeal. And I've also gone as far as to obtain the formal order from the previous court sitting, the claim in 2007, which predates the 2010 claim that involves all 99 persons, the 99 people on the land as at the time. Yeah. So the dispute has never been about who owns the land. That was not in dispute in 2007, not in dispute in 2010, not in dispute before Justice Campbell in 2014, and certainly not.
That's Justice Lennox Campbell.
Right.
That's why
The
Jordan
dispute began
lied.
in 2007, so it has now been running for 19 years. And it concerns about 9 acres of the land that has been occupied by a group of persons, said to be about 100 families, some of who have claimed to be there for more than 15 years, and some who says their families have been there for generations. They have built permanent concrete structures, they had water and electricity connected, and the judgment, again, describes it as a vibrant community. That description matters. And further down, George, you'll see why I paint that picture.
Stick up in. Listeners, viewers, audience, remember, the judgments that Saeed has examined describe it as a vibrant community. That is going to loom large in the further answers that Saeed will provide later on. Just remember, the judgment, it's not his opinion, the judgments of the court describe Orange Grove as a vibrant community.
My opinion comes out on the analysis of the judgments that I've read.
That's right. All right. Let's squeeze this one in before the break, and take your time because we're going to have the time. What did the Supreme Court decide in the year of our Lord 2010?
So, in 2010, 2007, first of all, let's go back to that. New Falmouth Resorts Limited, they brought a claim against 99 persons for recovery of possession. That is an ordinary claim a registered owner brings against a person occupying their property without permission. That actually turned out to be a long trial before Justice Donald McIntosh. For it to be a long trial, George, and this is based on our experience in the legal system, it means that the defense that they had to the recovery of possession claim from the company was that they adversely possessed the property by means of being there for more than 12 years, undisturbed and in open possession. In 2010, April 6 to be specific, judgment came in favor of the company, and the judge made 3 orders. 1, recovery of possession of the land. 2, he ordered each defendant to pay damages of $50,000 for trespass and wrongful occupation. And 3, he ordered the defendants to demolish and remove their illegal structures from the land. And he granted an injunction restraining any further construction by any other defendant. And that third order is the one that's important, George, because the court did not simply say that they must leave. The court said they must pull down what they had built 16 years ago. It is unchallenged. It is on the record. They did not pay the damages. They did not demolish. They did not remove the structures. That judgment, that 2010 judgment, was never appealed, and it stands even today as the final judgment from the Supreme Court.
Very important. You hear what Saeed said? Those 3 orders, go again, not challenged. They didn't pay what the court ordered them to pay. They did not demolish, and they did not remove any structure. And that 2010 judgment, which ordered them to do those things, went unappealed. All right, very important. All right, stick with us. We have more ground to cover, and we're going to take the time to do it because this thing is so important, because there are so many gaps, so many questions to answer, and we're trying our best to answer them for you, leaning heavily on Saeed Bernard's legal expertise and experience.
Thank God for people like George. Then nah, listen to them something right now. Nah, listen to them something
Visit
here.
Marshall's Pharmacy, where to vote more for all your prescription needs, gifts, personal care.
We wait for them to come back. Connecting, you can go on until them come back.
Yeah, man, I was talking about Emily.
Say Vegas, yeah. Oh, add up Vegas.
I was talking about Emily and how she was able to dice up the thing.
And Petal, it is not Vegas, it is Mr. Simit OD.
OD. Out of distinction. Welcome,
Mr. OD. Mr. OD.
Yes, ma'am.
Where I go?
So some fundamental things. New the Petal, new.
Oh, sorry.
Some very important things came out from Emily's presentation, even before George. Some very important things I'll be discussing, you know.
We're playing it, Betsy.
But for the court to hold the view that the PNP government was trying to pervert the course of justice, that is just tell when we come here in a chop and tell people about the PNP, like somebody like me know the PNP very nice 70s, 80s, and come right up. And I said, no, they think it's because we are labor rights. Support the party why we talk. And facts with them. Hard, cold, bare facts. That cannot be disputed. Understand? And by the way, the minister at the time was Omar Davis. The junior minister was Dr. Morris guy.
Omar was the man. Minister of
1 minute.
Correct.
1 minute.
Correct.
Well, Philippe, you get
1 minute.
I think some parts of it. Some
Excited, Mama Road.
Nice, Philippine, nice.
I'm not finished.
Yes, them are gonna put the thing in I think because it was
carpet. Look on carpet.
Which part when it's out that Philippine?
Look on carpet.
Which part when it's out that Philippine?
Look on carpet.
Huh?
And then
my own was start, you know, guys.
Yeah, man. See, that's right.
Yeah, man. My own was start, you know, trucks in another couple of days. As we just wait and up the China coming with the equipment.
All right. We're back.
I'm here to facilitate his explanation of the key issues surrounding this Cooper's Pen land dispute in Trelawney. That specifically that piece of property called Orange Grove, which has been the subject of much controversy after police accompanied the developers to demolish several homes earlier this week on Tuesday morning, putting scores of families out of their homes, unsettling lives, upending livelihoods. And we're here to answer some key questions. What Said Bernard has told us so far, based on his analysis of the court judgments and related material, is that in 2007, the company that owned the land, New Falmouth Resorts, it brought a claim against 99 people who had squatted on the land for recovery of said land. On April 6, 2010, 3 years later, Justice McIntosh delivered a judgment in favor of the company and ordered the company to recover possession of the land, ordered each of the 99 defendants to pay damages of $50,000 for trespass and wrongful occupation. He also ordered the defendants to demolish and remove their illegal structures from the land and granted an injunction restraining any further construction. Said told us before the break that none of the orders from the court were respected by the defendants, and the judgment was never appealed. So now, Said,
and before you go to the next question, I want to make a point, because when you look on the formal order of that 2007 judgment for recovery of possession, the 99 defendants, one of the defendants, in fact the 85th defendant, was persons unknown. You hear many people saying, oh, but I never know about the judgment, or I don't know if I was around at that time or whatever. The persons unknown here, as is listed as a defendant, mean if you're upon the land.
Yeah.
Quite simple.
Right.
Good. All right. So, what happened after 2010, Saeed? Did the matter simply go quiet? Did it disappear? What happened?
No. In fact, it went opposite. The evidence accepted by the courts in the 2010 case, where the minister got involved in, there was literally an expansion of the community. So the judge made an order, the community expanded. And the turning point came when the company, in trying to enforce the judgment that they got, they approached JPS to have the electricity supply to the unlawful occupants discontinued. That is what triggered a wave of applications now in early 2012 to stop the eviction. So that segues right to the heart of the story, I think, George. And that explains why the court eventually spoke how it did.
Yes.
Because in March 2012, 2 applications were filed. One in the 2007 claim for a stay of execution of that judge's judgment for demolition and recovery of possession, and another for an injunction to stop the company from interfering with the occupants. On the face of these applications, George, what was brought against the 99 defendants, but in substance, it was driven by the housing minister.
Who at the time was Dr. Maurice Guy.
Dr. Maurice Guy, I'm learning. The supporting affidavits were sworn by Mr. Joseph Shakir, who is the managing director of Jamaica, the housing agency of Jamaica at the time. And he described himself in the affidavit as the duly authorized agent of the Ministry of Housing. The basis of the application was that in February 2012, the minister had declared the lands an improvement area under Section 6 of the Housing Act, which the minister said left him at liberty to compulsorily acquire the land under the Land Acquisition Act. In May 2012, so this is months later, the minister then went ahead and lodged a caveat.
This is that controversial caveat.
And I'm going to get to that, George. The minister went and lodged a caveat against the company's title, which had the practical effect of freezing, not of dispelling, but of freezing the owner's ability to deal with the land as he or she saw fit. Yeah, they went on in May of that said year, the same days later actually, to then gazette the declaration of that being an improvement area. Now, when somebody places a caveat on a title, a caveat is there to say, I am stopping you from doing anything until a court has ruled. So you don't just lodge a caveat and you leave it like that and think that nothing will happen. The caveat can be warned, it can be cautioned, and things go on. But ultimately, George and listeners, once the court makes a ruling on the determination of the land as it relates to its legal and equitable interest, then the caveat, to my mind, is of no moment.
Hear me now. Good. You spoke just now about the minister moving to declare the area an improvement area. Therefore, what is an improvement area and what was the minister trying to achieve by virtue of this designation?
So the Housing Act actually gives the minister very important powers. Section 4, for example, it allows the minister to declare a housing area where further housing accommodation is needed. Section 5 deals with slum conditions and slum clearance, where conditions are so bad that you just need to demolish the entire area. Section 6 of the Housing Act, it deals with the improvement schemes, where houses are in an unfit area by way of, shoddy house management, or the roads are too small, it is unfit for human habitation through disrepair or sanitary defects, and frankly speaking, dangerous to the health of those who occupy it. Yes? Section 25 then provides that land proposed to be acquired for such an approved scheme may be acquired under the Land Acquisition Act, and that the purpose is deemed to be a public purpose. And I'm going to come back to that. Very important. The purpose must be for a public purpose. So based on what happened in the case, the strategy seems to be discharged. You declare the land an improvement area. You use that declaration to compulsorily acquire it from the owner. You pay the owner compensation. And you would be familiar with this. NROC does it when you want to, build roads, you buy the land from the person. But that's a public purpose, you want roads. Then you regularize the occupants on the land that were already on the land. In one sense, to my mind, it's a humane objective. People need to live. Some says land is for the people. But the difficulty with the act is that it was not designed to do that. And the evidence put before the court did not come close to meeting the statutory obligations.
So stick up in then. All right. What then did Justice McIntosh say when this matter returned to him, came back before him in 2012?
He said this, and I'm going to quote it here. It's at paragraph 10. It was so important that it was quoted back by the judges of the Court of Appeal. Given the history of this case, because he had refused the application by this time for the injunction, and he spoke very, very strongly. In fact, he asked the minister to come to court. He did not come. He noted the presence of the legal officers of the housing agency, and he handed them a written copy of his judgment. His written reasons are part of it, paragraph 10, as quoted in the Court of Appeal. It says, given the history of the case, the length of the trial, and the efforts made by the court to assist the defendants, who seem to have been misled by politicians into squatting on private property, notwithstanding their unlawful act, this court emphasizes with the gullible defendants. The application is iniquitous. It may be that the law is not a shackle to the lawmakers. That does not apply to the court, which must dispense to the law. It is the court's view that the application is devoid of sincerity. It is an attempt to pervert the course of justice and an abuse of the process of the court.
Wow. Wow. Justice McIntosh speaking as assertively as that, saying, let me repeat, that the defendants seem to have been, quote, misled by politicians into squatting on private property. Notwithstanding their unlawful act, the court empathizes with the gullible defendants. Not all words, his words. All right. So, therefore, what happened when the minister, subsequent to this judgment, then sued New Falmouth Resorts, the owner of the land, and sued them in his own name?
So he then went on now, George, to file a fresh claim. And when you say a fresh claim, new claim. And he placed himself at the forefront now as the claimant, and New Falmouth Resorts as the defendant. He sought several declarations. Among them was that he was entitled to compulsorily acquire the land, that the Commissioner of Lands could take possession of the land, and that the land now vested in the Commissioner of Lands. He sought the injunctions I spoke of earlier, restraining the owner from dealing with his own land, and from evicting, an injunction from evicting and disturbing the occupants, and from demolishing or altering the structures. New Falmouth applied to strike out that claim. And when he says strike out, he's telling judge, don't listen to this claim. It has no place in this court. Throw it out. And the matter was heard by Justice Campbell over 5 days. And in 2014 of February, he refused the minister's application for an injunction and struck out the minister's claim entirely. And he gave several reasons, George, as to why he struck it out.
Yes.
He said that one, they didn't satisfy the statutory conditions. What are the statutory conditions? He says that there was no evidence that the minister actually considered housing conditions in the area. There was no evidence of a prepared housing scheme under Section 4.2, nor a prepared housing scheme under Section 6.2, and no approval from the said minister under Section 11. He was referring to the said act that would allow you to make the declaration, but there are certain preliminary steps that had to be done and taken before and after, before it got to this stage. Those were not taken. What is striking to my mind is the government's own evidence, to my mind, defeated the case. Because the affidavit of Simone Morris Rattray, who was, as at the time, the senior legal officer and the minister's own authorized agent, this is her affidavit. She said that nearly all the occupants had permanent concrete structures with water and electricity, and described the settlement as a vibrant community. But Section 6 of the Housing Act requires the opposite.
Yes.
And I went through what would be required by Section 6. I can go back to Section 6.
I will put a pick up for just go on.
Clearance where conditions are so bad that, no, that's Section 5. Section 6 deals with improvement schemes where the houses in an area are unfit for human habitation through disrepair or sanitary defects, or are dangerous to health because of bad arrangement, narrow or badly arranged streets, or overcrowded. Yeah? Section 6 here, based on the affidavit, it says permanent concrete structures with water and electricity and a vibrant community.
Yeah.
it requires houses unfit for human habitation. I just went through what Section 6 means. He also went on, the judge, to say there was no public purpose, and that is the constitutional core of the case, and I'll deal with it separately. He spoke about the balance of convenience, the fact that the judge, the balance of convenience, the judge thought that it favored the company because the company has been trying to do every single thing to get the people out. And as a matter of fact, when you're seeking an injunction in legal cases, George, there is usually something that you have to put in the application that you undertake to cover damages that arise from an injunction.
Yes.
That was not given.
Yes.
That undertaking was not given.
Yes.
Then the judge went on to say that the claimant's own conduct, he quoted an equitable maxim. He says, he who comes to equity must come with clean hands. Because apparently a valuation of the owner's property had been procured with no explanation of the authority under which that was done. And then the minister had gone on to gazette the declaration after a judge had already ruled, and that was disregarded by the minister. The judge took that into consideration.
All right. After the break, we have to take the break. It's 6 o'clock. You're going to explain to the listeners, from your perspective, why the court found that there was no public purpose element strong enough to compel him to side with the government in this matter. Well, the then government in this matter of the Cooper's Bend land dispute with the owners, New Falmouth Resorts. After the break.
Me say, I hope you follow the part, you know, where them say the evidence where the government presented at the time is what they feed them case. Because them say, a poor people is there, so we have to take it over. But when they present the house, so electricity and water, they then as a vibrant community. The judge said that no.
No, because the law don't speak to that. The law don't speak to that.
What them going to do? They never do nothing to Jamaica under their leadership. What plans they have for the community? They can't even say what plans they have for the community.
That's everything. They are so goddamn lazy. They are so goddamn lazy that even if they did present a plan to the judge, say here is what we plan to do with the community, they would have won. If they had presented a plan, they would have won. My Lord. That's why I borrow your back, yeah? So bring your back.
Excuse quick, Chuck.
Yeah, man, got you.
I totally disagree with that pronouncement. Totally disagree. They couldn't have presented such. They couldn't have, and they knew this. They couldn't go tell the judge, said them go created none of the clause in 4 or 6, because that was not happening there. In order for them to say they have a plan to even go there, so they may have to prove why they have a plan. The house, the hero was a vibrant community. They knew this. So they couldn't go with the argument. The judge that run them further. The judge that run them wrong in their court, it's all long. They couldn't go with the argument, brother. What them do, them go in, they go present this section of the Housing Act and defeat them own argument. Nobody never forgot to do the research, because if they present that argument, Chuck, and then further investigation was conducted, then them not prove them to be liars. So them in this them own affidavit, the judge nobody never have to do no investigation. Them do it themselves and prove themselves to be insincere.
But Chuck.
Hold on, sir. Make Fortune finish.
So them couldn't win the case. They had no chance, brother. They had zero chance. What they did was they knew they had no chance, and they keep promising the people them say them are going to get the land, brother.
Them are going to get the land.
That is the crux of the conversation.
And that's what the judge put in and reading.
That's why the judge rebuked them.
Have been misled by politicians.
Yes.
I have a quick Chuck, you see this when me send you with the Mark Golding pretend saying I know shit, and a law firm represented the case in 2002.
Okay, wait then. No, me not see that.
Me send it to you. Look.
All right.
But Chuck, the JP.
Hold on, Sean. Just wait. Just give me a second. I think I'm so look on it. Yeah.
Give me a minute, Chuck. Please. Give me a minute.
Sorry, I'm connecting. They're back from the break.
Between New Falmouth Resort, the company that owns that controversial piece of land, Orange Grove, Cooper Pen in Trelawney, which was the site of a demolition exercise earlier this week. And we've heard a lot of comments about who's in the right, actions of the government then, the things that the government now ought to do, the rights of squatters, the rights of property owners, all of that. And so we've asked Saeed Bernard to read the judgments, analyze them, and take from the judgments the salient points that can answer the questions that you have about this matter to help your own understanding. Where we had left the conversation at the break was that Saeed had told us that the Minister of Housing at the time, he went to the court and filed a fresh claim. He wanted the court to rule that the minister was now entitled to compulsorily acquire the land, that the Commissioner of Lands could take possession of the land, and that the land was now vested in the Commissioner of Lands. He also sought injunctions restraining the owner, New Falmouth Resort, from dealing with their own land, restrain them from evicting or disturbing the squatters, and from demolishing or altering any of the structures. Justice Campbell heard the matter over 5 days, and he refused the minister's application, and he gave several reasons. Saeed says that very important among the reasons was that the court found that there was no public purpose element of the minister's claim. Why did the court find that there was no public purpose element in this matter, Mr. Bernard?
Now imagine, George, you live in a country where you've worked hard, you've saved, you pull shifts, you've been here from morning, and you're still here. You buy a piece of land, and the government just comes and says, I'm going to take the property from you, I'm going to buy it from you because I'm going to give it to me. Yeah? That is what the Constitution can't allow.
Yes.
And Section 18 of the Constitution, it allows for the compulsory acquisition of land under that law and compensation, access to the court, but it must be for a public purpose. Yeah? Now the judge, when we're referring back to Section 25 of the Housing Act, he says it creates a presumption that acquisition for a scheme is for a public purpose. But he held that that presumption is rebuttable, and that the court is entitled to look beyond the veil, look beyond the stated purpose, look beyond what is in the affidavits, look beyond what the minister has said, and see whether or not it is a sham. Now, this principle of law, George, takes shape from the 1800s in a case called Street and Montfort, Road in England, where the judge said, you cannot call a spoon a fork, and it must be accepted as a fork. You must look beyond. And if you call it a fork, it does not matter as long as the subject looks and operates like a spoon. Same principle here. So, Justice Campbell went on in paragraph 36 of the judgment, frankly speaking, very blunt, to say the stated or alleged purpose of the claimant, the Minister of Housing, is not for general interest of the community, but merely for private individuals voluntarily associated together for their own benefit. There can be no public purpose or furtherance of the general interest of the community as opposed to the particular interest of individuals, requiring the respondent to locate these families on its land in flagrant breach of the orders of this court. It tells me, George, that Justice Campbell here was very upset as to what took place after his sister judge made rulings in 2007.
Yeah, very well. All right. So there are some passages that I'm sure you would have highlighted as you read, and they reflect what the court had to say about the overall matter. You've mentioned paragraphs 36 and 38. Any other paragraphs that caught your eye and why?
Yes, 46 of the judgment of Justice Campbell's judgment, 47 as well. He says the Housing Act and the Land Acquisition Act do not provide for the compulsory acquisition of privately owned land in order to transfer an interest to a community of persons who have occupied those lands despite their efforts of the owner to evict. Very important.
Yes.
This dispels any labeling of adverse possession because you're not in open, undisturbed possession.
Yes, it's not undisturbed.
No, it's not undisturbed, despite the efforts of the owner to evict. And furthermore, again, the judge is upset because it is in defiance of the orders of the Supreme Court. I share the view of my brother, Justice McIntosh, that the application of the claimant is insincere and iniquitous. The Constitution protects private property and does not provide cover for the acquisition of private property.
So the court basically called PMP
lawful occupation of squatters.
Very important.
It goes on in paragraph 47. I have not been shown any authority that imposes an obligation on a private landowner to make available his land to a community of persons in unlawful occupation in order to prevent those persons bringing on social unrest. The Constitution does not reserve the right to ownership of large tracts of land to persons of any particular social class, color, or creed. Justice McIntosh was driven to describe the earlier application on behalf of the occupants as insincere and iniquitous. The third time now, using these same two words.
Insincere and iniquitous.
No doubt because of the total disregard for the defendant's fundamental rights. This court has formed the view that the hardship that has been visited on the defendant appears to be a consequence of a view on which public officials and the claimant seemed to have acted that Mr. Chisholm, and this is the most potent, powerful stuff, read it, Said. Mr. Chisholm, not being from a line of traditional large landowners, has no right to ownership of such relatively large tracts of land.
Hold on. Mute that there. Hold on, Side. Miss will come to you.
The remedy to...
So the judge said the PMP don't believe that this is like a poor man supposed to own such a big piece of land. And that the judge just telling saying, the judge said, "Uno don't believe that this is like a poor."
That malady is an emancipation of those minds so enslaved. Wow. I don't want it to miss that. It's basically saying a Jamaican businessman is treated differently by the state because he did not come from the traditional landowning class.
Yes.
George, the state would not move this way if it was against a plantation family.
Yeah. Big name, old money, he's not. So because he's a small man not supposed to own so much land. So because he's a small man, not from a big landowning family, we're moving against him to take the land, is what the judge is saying.
Judge is saying it would not have occurred.
So PMP are fight poor people.
So why did the court say the minister could not bring the case a second time, could not keep going to the court to get his way?
So two related principles, and I have to spell it out for the listeners. Res judicata, that means a matter already decided by a competent court cannot be litigated again. And abuse of process, a broader principle,
Right, the feel brilliant, somebody know that
that could and should have been raised the first time. So you can't raise it now that you just think about it. You should have raised it in the previous case. The minister answered that question to say that the claim in 2007 he was not a party to. Because there were 99 defendants, he was not a party to that. Yes? Now, he also went on to say that that's a private law matter. He now being involved, the Minister of Housing, it now becomes a public law matter. The judge rejected that, and the Court of Appeal also rejected that argument. The affidavit in both sets of proceedings came from the same deponents, describing themselves as the minister's authorized agents. The minister's officers appeared in court. The same ministerial declaration was the foundation of both. The Court of Appeal actually said, in my view, the minister cannot now seek to detach himself from the proceedings by merely stating that he was not a party to those proceedings, especially where it is clear that at all material times he proposed to act on behalf of the 99 defendants or to help them achieve their original objective in litigation.
Very well. 6:14. I'm not hearing go to break yet, so I'm going to soldier on. What did the Court of Appeal decide now, Said, in 2016?
So the Court of Appeal now, having heard the case, Justice Williams wrote the judgment. And a part of this panel, I will say, is Justice Phillips and Justice Brooks, who later on became a president of the Court of Appeal. Now, the Court of Appeal upheld every single material point of the Supreme Court. It upheld everything. On the statutory failures, it went further than the Supreme Court. It found that the 9-month period under Section A2, not satisfied. The evidence of ministerial approval under Section 11, not satisfied. The compliance needed under Section 8.1, which requires publication of a notice stating that there was a plan to be inspected and all of that, not satisfied. So overall, the Court of Appeal said what appeared to have been at play was, at best, a misguided attempt to use the provisions of the Act in an effort to achieve certain social objectives for which the Act did not provide. The conclusion then of that judge, Justice of Appeal Williams, the later claim having been in substance the same as the earlier claim and appearing to have the effect of attempting to circumvent the orders of Justice McIntosh, they clearly amounted to an abuse of process of the court. That fact, coupled with the minister's failure to demonstrate compliance with the requirements of Section 6 of the Act, helped to seal the fate of his applications. Since then, 2016, no further appeal to the Privy Council. That is where the litigation ended. Yes, April 2016.
April 2016, all of the court matters around this matter ceased to be. They ended April 2016. So therefore, with all of the court matters ending in April 2016, what is the legal effect of all of what went before, and why can the owner now move to demolish?
I have to take a deep breath.
Yes.
This is tiring. So the legal effect of what has taken place now, George, and I'm trying to put it as simple as possible, because every legal route that the occupants had, in other words, if those occupants came to me and they showed me all of this, I just said, you have no other choice at this point. You've tried everything. The minister tried to help you and the minister failed to. You don't have any choice at this point. So their claim to the land by adverse possession was tried and rejected in 2010. Order for recovery of possession, never appealed, stands final. Application to stay that order was refused in 2012, not appealed. The government's attempt to acquire that land struck out in 2014. The appeal against that ruling in 2014 was dismissed in 2016. No compensation, no damages, no cost ordered against the occupants have ever been paid. So the owner holds a final, unappealed judgment of the Supreme Court for possession, together with an order that the structures be removed and no legal impediment enforcing it. What happened on Tuesday morning is literally the end of the road. It is the end of the road. It's not something new that came up. It's not the beginning of a new road. It's the end of the road that started in 2016.
Argument done.
A quick break there, Andrew, to give Saeed time to catch his breath, because there's still more ground to cover, because I want to ask you after the break, was the owner required to give the residents notice before moving to demolish? That after the break.
All right, guys, we have about a minute before they come back. What are you saying connecting? Sorry, John, you just say beg a minute as you come. Where are you?
Them have moderation side, you know.
That's something about Chuck, we don't want somebody to go over read the money. Have the information. Because I'll be over there with Navi.
We not go there.
We not go over read. We not go
Navi is a future lawyer. We don't have to go over there. Navi knows how to handle herself.
We don't know why Navi over there.
No, but believe me. Alvira have her over there. I spread that. Boy, I don't know, but you get by when you realize them.
The facts over nationwide a liar.
Do me a favor, John. Go over there and type in at the chat. Say anybody want to listen facts come over Chuck.
All right.
Let's type that in the chat.
All right.
Say if you want to listen good, come over Chuck.
Me reach at work.
Exactly.
Come out of box.
All right
then. They
don't listen.
Yeah, man. Just go over there and type. If you don't want facts, go over Chuck. Sorry. Where's the connect?
I waste time to go over there, so.
Yeah, don't go over by Reedy, guys. Do not go over by Reedy. He's a paid PMP blogger.
Simple put. Yeah, connected. Where else before them come back?
Attempting to pervert the course of justice means a severe common law offense. Sorry. Means a severe common law offense that occurs when someone intentionally takes action to interfere with the administration of justice. And I give some examples.
His expertise as a lawyer,
Fabricating evidence.
as he is analyzed.
All right, protecting them back again
on this matter, and he has highlighted the opinions of the judges who've sat in on the matters brought before them concerning the ownership of the land and the possession of the land and the occupation of the land. And we have a few furlongs to cover, just a few more. So just to recap quickly before the break, Saeed told us that the 99 defendants, including a nebulous group called Persons Unknown.
Persons Unknown.
Yeah? Their claim to the land that is owned by New Falmouth Resorts, that claim to the land by a long possession was tried and rejected by the court in 2010. The order for recovery of possession by the owners of their land, that order was never appealed and stands as final. The application by the occupiers of the land to stay an order was refused in 2012 and they did not appeal. The government's attempt, when the government entered the fray, when the Minister of Housing, Dr. Maurice Guy, entered and sued in his own name, that attempt to acquire for the land for the occupiers was struck out by the court in 2014. The appeal to that striking out was dismissed in 2016. The court along the way ordered for the occupiers, the squatters, to pay compensation, to pay damages. None of that was ever honored by the occupiers of the land. Yeah? And so the owner, Saeed Bernard, says, holds a final unappealed judgment of the Supreme Court for possession, together with an order that the structures be removed and no legal impediment to enforcing it. He said, Saeed Bernard said what happened on Tuesday was the end of the road, not the beginning of a new one. So therefore I ask you now, counsel, was the owner required to give the residents notice before demolishing?
George, in the break, before I answer that question directly, this issue has been made to be a political class issue.
Yes.
A class issue. Poor people, land belongs to the people and all of that. What the judge was doing here, and I think it's important to bring it up, because from this time, 2010, 2013, the judge picked up on that and made the declaration that he did. He drew on the Bob Marley, he drew on the ideology of Marcus Garvey in saying that if this was a plantation owner, a family name owner, this case would not have been here. It pales in comparison to what we're hearing now, where it is poor people, so they're supposed to get the land. What about persons who have worked to try and bring themselves up to the social ladder? And this is where the judge is having the difficulty to say the Constitution goes both ways. It goes both ways. No, the court, where am I? Yes. Demolishing now?
No, no. I asked you if the owner was required to give the notice. There's notice before demolition.
Right.
Yes.
So, as it relates to this, I am going to stick to the facts as I have seen them in the case. A judgment for recovery of possession is enforced by what is called, ladies and gentlemen, a writ of possession. And that is executed by a bailiff. So you recall at the start of the program, I said that a bailiff was there, meaning that the bailiff was there on the court's business to execute an order.
He was supervising the process of demolition, yes.
Right. The writ of possession is what is executed by that bailiff. The occupants in this case, the parties to the 2007 claim, they were served, they'd have to be served, represented, attended trial, order made against them. So in law, the judgment itself is now their notice. There is no requirement that fresh notice be given. None. Not to my mind.
Yes.
Yes? And because no fresh notice is needed, because the court has already ordered them, they have the order. Mm-hmm. That said, 3 qualifications are there that I will make. Firstly, the 2010 order bound the 99 named defendants. And the evidence in both judgments is that the settlement grew after 2010.
Yes.
So whether every person whose house was leveled on Tuesday forms a part of that claim or a successor, they are bound by that order. And whether or not they are saying that they are not the 85th defendant by being persons unknown, that is a matter that, to my mind, a question of fact, I cannot answer based on the judgments. Secondly, an enforcement officer executing a writ of possession, they have to act within the terms of that writ. And thirdly, lawfulness and decency are not the same thing.
That's right.
They are not the same thing. The law permitted this. The law did not require that it be done at 3 o'clock in the morning. But the law allowed it. Simply put.
Yeah, all right. Very well. Can a judgment from 2010 still be enforced in 2026? Is it too late?
So that's a fair question because the court runs on time. But the short answer to that is a judgment does not expire. It doesn't. It remains a judgment until it is appealed and set aside, satisfied, or reversed by another judge. That did not happen here. The only thing that changes it to my mind is the time. Because 6 years have passed since the date of the judgment. The rules require that the judgment creditor, as in the person who the judgment is in favor of, the rules require that they get permission from the court to issue the execution as regards the judgment, to act on the judgment. And of course, the court would want to know, why was there a delay and all of that. Yes? But that does not come into play, George, because the formal order here that has the defendants before the Honorable Justice Chester Stamp in Chambers video conference dated the 19th day of May 2026, and that's the important part. 19th day of May 2026. It says, on the hearing of the notice of application filed on March 30, 2026, and coming on hearing on the 19th day of May 2026, it is hereby ordered as follows. An order is made, granted in terms of paragraphs 1, 2, and 3 of the notice of application for court orders that was filed on March 30. Paragraph 2 is to be amended to substitute creditor for the word debtors. I do not have the notice of application, so I cannot read that verbatim. But it goes on to say that the claimant be reissued a writ of possession. What does that mean, George? It means that a writ of possession was issued prior.
Before, yeah. So reissue. There you go.
Yeah? So this is a reissue, and you have to go back to the court to get that. To recover possession of the approximately 14.5 acres of the northerly portions of the land known as Orange Grove, south of Cooper's Pen and Burnwood Beach, being lands registered at the volume 1008, folio 636 of the registered book of titles in Trelawney, containing by survey 284 acres, 1 rood and 22 perches of the shape and dimensions and buttings as appear by the plan thereof. That's the language used.
To discuss the lay of the land anyway, with the things that are on the features.
Correct.
Yes.
So in other words, George, the owner has the order, a fresh order,
May 2026
to act on.
There you go. All right. What about the report? Now, we carried a report earlier this week based on some checks by our business and enterprise editor, Chevron Campbell, that the company New Falmouth Resorts was at risk of being struck from the company register. So someone may ask, what effect does that have on the ability of New Falmouth Resorts to proceed on the basis of a court order, given that it is risking deregistration from the company's office?
And that's a good question, but a separate issue. It should not be used to conflate or confuse the property issue at question. As you know, anti-money laundering and FATF, we've been in FATF, and in order to get the country in a particular position where money laundering is concerned, the Companies Office of Jamaica, along with FID, for example, customs, and various agencies, have to have a database of beneficial owners. Right? Now, what happens with New Falmouth Resorts is that they run the risk of being struck after 3 years for failure to file their beneficial ownership declaration. And that's a declaration now that every single company in Jamaica has to file. Right? So that became an amendment. It became a requirement through the amendment of the Companies Act, and it forms a part of the anti-money laundering framework. But that, George, does not undo the judgment. To my mind, it does not affect the title. It doesn't at all. A company that is in the process of being struck off is still on the register and still owns the property. And even if a company is eventually dissolved, the consequence is not that the squatters can take the land. The consequence under the Companies Act, and I'm in the teaching mood, so I might as well go there, is that the property passes to the Crown as ownerless property. And a company that has been struck off can apply to be restored to the register, at which point it would be treated as having continued in existence.
Yes.
So the deregistration story, it does raise legitimate questions about transparency and other things that have to be dealt with by them.
Yes.
But it does not change the story behind the land.
All right. After the break, Saeed, we have to take the break. I have one more question, and it concerns the social significance. And I wanted to bring back in that answer, if you can, what the judge said about the antecedents of the gentleman behind New Falmouth Resorts, and how he would have worked to acquire his property, which the government then tried to take from him over so many years and so many court proceedings. After the break, we get that as we wrap up this explainer nationwide style, nationwide at 5 on this Friday afternoon.
Final break before then go. So, fourth term, anything to add?
Drive the most exciting new vehicles in Jamaica. Schedule your 20.
My question is, right?
Term, just before you go, I want to say something to you. It's the first opportunity I'm getting to genuinely congratulate you.
Yeah, man, General, big up yourself, man, my teacher.
And your massive achievement. And listen to me now, man. I want to invite you to wear your crown with humility, but with pride.
Thanks,
Don't pay attention to the naysayers.
We must have been a good company, you know. We keep company with ex-police officers, ex-judges, lawyers, doctors. So,
much respect, man. Much respect.
Take a picture.
Cool.
Chuck. Mike, I wish you had asked the question. I don't know if he asked it, and I wish you had expounded a little more on it. Where the PMP now talk about them want to go. This government could have taken it to the Privy Council. So I don't know if anybody here can speak on it. How can you take something to the Privy Council that was basically rejected to even, get to the appeal process through the appeal process in Jamaica? How can you take that same document to the Privy Council if it was rejected by the people?
I think the way it works, is that if the appellate court reject it and you believe you were wrong by the appellate court, then you take it to a next level, which would be the Supreme Court.
You must remember
which would be the Privy Council. So it's just a matter of keep going until you feel satisfied.
But what documentation would they have taken to the Privy Council? That may I try to figure out.
I don't know. I don't know.
I don't want to get answered, because if basically everything that they provided go contrary, everything that they said and provided is contrary to the Housing Act, everything, every single thing. What documentation should this government take to the Privy Council? The same contrary argument? That may I try to figure out. Because this government would be idiotic to take the same contrary argument. This government will have to start all over.
That the argument that has been rejected by 3 different courts.
Yes, but remember saying, the courts, all 3 judges are court, rule that what they present is presenting is contrary. So is Mark Golding saying this administration should have taken something that was rejected as being contrary, insincere, and iniquitous to the Privy Council? Is that what he's saying?
That's exactly what he's saying.
I beg your pardon.
All right, they're back from the break.
The issues concerning the Cooper's
Them block you.
dispute and the steps that have been taken by 99 defendants, including a group classified as persons unknown, and the Minister of Housing, Dr. Maurice Guy, and our PMP administration, the steps that have been taken to acquire the land so that the people there could own the land, and the efforts that the owner of the land, New Falmouth Resorts, has made over all those years to take possession of the land. The court has ruled consistently in favor of New Falmouth Resorts, telling those who occupy the land to leave, demolish what they built, and to pay costs to New Falmouth Resorts. None of the court's orders have been obeyed. And in fact, after the court ordered certain things, the Minister of Housing went and gazetted something else. And the court was very upset that that had been done. I asked Said Bernard, after this masterclass from him, to sum it up by speaking to the social significance of this Cooper's Pen land dispute.
The social significance, George, is quite enormous, and it goes beyond Trelawney. Squatting in Jamaica is it's nothing on the fringe. Informal settlements are now a very large part of Jamaica. And behind almost every one of these settlements is the same set of facts. People with nowhere to go, land they do not own, years of political tolerance, and eventually a reckoning. What Cooper's Pen shows me is what happens when that reckoning is deferred for 2 decades. Justice McIntosh identified the underlying wrong as early as 2012, when he described the defendants as having seemingly been misled by politicians into squatting on private property, and said the court empathized with them while recognizing that what they had done was also unlawful. That is the tragedy of the case in a single sentence. The persons who lost their homes on Tuesday morning are, in large measure, the ones who were let down. They were encouraged to stay. They were told help was coming. Affidavits filed on their behalf by public officials. Minister declared their community an improvement area. And when all of that failed in court in 2016, nothing was put in its place. Nobody relocated them. Nobody bought the land. Nobody told them that 10 years of silence did not mean that the judgment had no effect. And this is also worth saying here plainly that the owner of this land is himself a Jamaican businessman who, on the evidence accepted by the judge, spent more than a decade writing to government agencies, to the housing agency, to the Prime Minister, asking for help to resolve the position of the very people on his land. And he received no help.
Can the person who take Chavi out of the box please stop it? Who do that?
The Jamaican businessman, he had people on his land. He spent 10 years writing to government agencies. On the evidence in the case, you can go and read it yourself. He wrote to the housing agency. He wrote to the Prime Minister asking for help to relocate the people on his land. He got no help. So this is not the case of a landowner who did nothing and then reached for a bulldozer. This is a case where everybody was asking the state to act or the state not to act, but the state did not act. And then there's a timing of this because many of the families just went through Hurricane Melissa and Darby building. But whatever the legal position, that fact will and should shape how we feel about what happens. Because a court order, it doesn't go stale. You can't just ignore it and let it just sit there. It might just be sitting and waiting. So I think the bigger lesson this afternoon, this evening, is for anyone who is occupying land they do not own. The message is to regularize your position now, while there is still someone to negotiate with. For landowners, the message is that the courts will protect a registered title, but that enforcement gets harder the longer you wait. And for the state, the government, the message is the one both courts have already given. The Housing Act is not an instrument for solving a political problem. And the Constitution is not a mechanism for taking one Jamaican's land to give to another.
Thank you very much, Counsel. Thank you very much. Thank you very much.
Thank you very much, listeners. We've put this into the public domain. We've leaned on Said's expertise and experience to look at all of the court proceedings concerning this matter. And that's where his answers come from. And the opinion he has formed is based on what he has read. We certainly hope that we have advanced your understanding of the issue. Here at Nationwide, we never tell you what to think. You're bright people. That's why you're part of the 4% family. You've heard that. You've heard other things. What do you believe? Where do you think truth lies? What do you take away from all that has happened this week? And how does it inform what you will demand from your leaders going forward? And how has it impacted your view of adverse possession, the issue of squatting, and the use of politics to solve a problem concerning governance? And what now do you understand where the Constitution is concerned and how it protects the rights of private landowners and the people who occupy said lands owned by private landowners? Said, I can't thank you enough, my friend. I'm going to take my leave. It's your program, it's not mine. So you're tired. You want to go lay down. All right, let me take the break, and when you come back, you still have some ground to cover with a statement from the Prime Minister on this issue. This is Nationwide at 5. I was a guest. Said, good afternoon. Good afternoon, listeners.
All right, brother, so we can't take the thing, but guys, there you have it. Real information. Shika?
Sure. Before Shika, I just want to say something quickly before Shika. And I want us to make sure so we get it in the head of the people them. Now the argument about the money no spend for donation and the place them no build up yet and you see why it is important for the government to follow due process. Chuck, you realize some people are not think of them. Are claim the people then suppose
a long time we are tell them we say government can't run in and build you one house or help you build one house without proof.
Because most of them people are saying them land, you know. Then what if the government could build some infrastructure over the money land?
And the sad part is, most of them believe it, because them live there so long. They believe it. My mother used to live there.
Fourth term. Can you imagine if the government is going to put up 2 social housing?
That's what I'm saying. I go put 2 container houses with the place.
You understand me?
Can you imagine how stupid Andrew will listen to today?
Guys, let me ask you a question.
Me can't bother with everybody attack one time. You know, have to just wait until people finish. Can you guys just mute your mic and make the people them finish talk, please? We can't attack over people. You don't make sense.
Fourth term.
What I'm saying is, if the government had gone over to Chilani and put up some base and some container houses, or put up some quick and build like ice, we name chop the line boss. Then I say, them to build up real house, give the people or you can build it up quickly. If the government had followed his advice and go put houses over the plan, you know, some a bulldozer we don't see run through them also right now.
Pure crosses.
Then I say, Andrew, waste the hurricane relief money. Jesus.
Well, I'm going to jump. I just want to make a quick suggestion to Chuck and others. You see these 2 tapes, one with Emily, and this one is very detailed and comprehensive, very, very comprehensive, the last one here. So you might have to cut them up as you normally do. And play them and replay them, because I'm telling you something, they are very, very, a lot of information. And even though I was here listening and multitasking, but I still need to go back over them to be able to make an intelligent and informed contribution about them. But one thing I can say, I have always held the view that this organization known as the Pandemic National Party is a dangerous, corrupt, cultist, criminal organization, and I'm not going to deviate on that. I will never stop saying that, because I know them. what came out of these presentations this evening, it is making clear. The Supreme Court judge called the minister and by extension, the Pandemic National Party corrupt. The judge called them corrupt. You be the queen, yeah, eh?
Iniquitous, corrupt, deceptive, thieves.
We're gonna go to Bashan and then we go to Sam.
No,
look here.
It's about the family here.
All right.
All right.
Did JPS regularize light in a Cooper Spring? We don't know if anybody can answer that.
I think there was some light there and the owner to go to court to have them remove it.
So why also all comes
guys, we're gonna break. We're gonna listen to the Prime Minister shoot shortly, quick.
Based on the time.
People, me late for work tonight, if they fire me, I have to go pay me, you know. If they fire me, I have to go start saying me lion and tiger every day.
Stop it, guys. You're seeing a management.
Was Prime Minister at the time. But the current Prime Minister, Dr. Andrew Holness, says his administration will not condone squatting or the illegal occupation of the land. He has several things to say when he was speaking in Southwest St. Anne.
It is not built on government land. And I want to make that distinction. This is not built on government land. Neither is Pauline capturing this land. Because any program that I have anything to do with must be lawfully done. And so if we are going to build house, we're not building and capture land. We take the time to find out whose land it is, and if it is not Pauline's land, Pauline has to get permission. And not just a 2-year or a 5-year or a 10-year or a 2-shot to get what is it we have enough years? 40, more than 40 years. What is it? You have to get a 99-year lease, meaning a lifetime.
99-year lease.
Before we put down any structure on the land. Why is it that we do this? Because government could go and just build on any land. But what kind of example would that say? You know that there is a raging conversation going on now about a particular community in Trelawney. The incident is quite concerning, and many of the images that we have seen are disturbing. My heart goes out to the families who have been dislocated. I see a particular image of a newborn and the mother being displaced. These are the tragedies of our history. And it is one thing that history does, is to repeat itself. And I am committed to ensure that our history is not repeated. Which is why I am unequivocal and very clear in not endorsing squatting and the illegal occupation of land. As your Prime Minister, I have been unequivocal and very clear. I do intend to address the specific matter when I have the full details of the matter. The matter is quite complex and it involves court rulings for which I need to be properly advised on those court rulings before I speak. I do intend to, however, address the matter as soon as the matter occurred and it was brought to my attention. I had no prior knowledge of it. None of our ministers, certainly not the Member of Parliament. I got a call very early in the morning, quite surprised, and immediately we mobilized resources from ADPEM and the Ministry of Labour and Social Security to assist because technically it was a disaster. Luckily, we were very frugal and responsible in how we use the materials that we were able to respond with. We never use off what we didn't need to use off. So what we got in aid and support and what we bought in stock, we never wasted.
She can think I mean what you would.
We put it down carefully so that when the next disaster strike, whether it is hurricane or an untimely relocation and dislocating exercise, we are able to respond to the people. And we have been able to respond in the humanitarian crisis that has been created. There is a longer term response that is necessary. And as all of you stand here, there are some of you who are occupying land for which you have not yet certified the occupancy.
What do you mean by?
You have no title. Some of you have no lease, no permission. Some of you it's land that has been handed down from your grandparents' time and you have been on it for how long, but it's not formalized. And others of you have been just living on land that you go and see nobody using it and you use it. Now, Jamaica can't develop with informality.
No, we can't.
But Jamaica cannot develop with unfairness as well. So whatever the government does, it has to address the issue of informality, and we can't be too mouth about it. We have to speak straight about it. Squatting is wrong. Informal settlement is not encouraged. But yes, every single Jamaican should have equal opportunity to get access to land and housing. The two things are not in contravention of each other. Not in contravention. Now, we will be addressing the issue. We will have to find ways to support those families who are impacted. But whatever our response is, we have to be careful that we don't set a precedence that is not sustainable. Because whatever we do now, everybody's going to expect that it is done going forward. So, which is why we are being very careful
there's a request in the line there.
preparing a response that is sustainable. And mind you, this is not the only repossession, dislocation, eviction that is occurring. And it is occurring on private property, but it is becoming a public concern. So we have to be very careful in crafting a response. You know, what is amazing, and as I have your attention for another minute or so, everyone will say the government must respond. The government must do something. Yes, the government must respond. Yes, the government must do something. But what is the government going to respond with? Your tax dollars, your funds that the government is going to respond. It's your funds. So you need to take an interest in how those funds will be used.
Go in the big screen, Chuck.
Because the government can't respond and say, all right, everybody who is squatting, everybody who is illegally occupied, we're going to give you land. Or we're going to build a house for you. Well, what happened to the people who are occupying their lands legally but don't have a house anymore? What about other people who have followed the rule but are in difficult circumstances? What about them? Do we divert resources from them to this? So we have to think about the response very carefully. I want to say here that as a society we must draw a line on this business of the illegal occupation of land. But at the same time, we need to turn a new page on how we make lands available to the people of Jamaica. Not just lands, but housing. Because that is a challenge. The problem that we are having is that we are just not delivering enough housing solutions at the price and at the scale that people would want. That is the main challenge. The truth is that if the people who occupied Cooper's Pen, if they could have gone and gotten a house at a price point that they could manage, they would do it. And so the conversation has to change to how do we get more houses constructed in a formal community much faster at prices that people can afford. That is the real solution, right? The solution can't be, which has been promoted by politicians in the past, which is you see that little piece of land there, one go settle it, and then afterwards we come and correct it. That's the genesis of this problem. That's the history that has repeated, that has gotten us here. The politicians who are talking now, they are a part of that problem. They were the ones who winked at people and told them, go and occupy the land, and then afterwards we correct it.
Yes, yes.
I can swear here that I am not a part of that. I wasn't born when those things were going on. I was a little behind. And I see some of them talking now who are responsible for it. They are responsible for it. And now it has fallen to me to correct it.
And you will, my Prime Minister. You will.
And it will be corrected. In the same way we have developed this program, which every week I'm delivering a house to someone who is in need, a social house to someone who has a social challenge. It is the same way that we will develop a program to address squatter communities, irregularly settled communities, formalize them, regularize them, and prevent further squatting and informal settlement. That has to be the way to go.
Dr. Andrew Holmes,
that is the PM.
Minister speaking there, the handing over of a house in Southwest.
That is the PM. So, Mr. UIC, he said UIC have a different plan.
you know where